just to go through some of the slides, and how I will take it is there are many amendments also that has come over a period of time. So slide by slide, I'll just give the background, and then we will go through section wise and important sections and practical aspects involved in them. And in the end, we will take the practical question answer session, last half an hour or so. Uh, and in between, maybe there may be an interruption for 5 minutes because I have to appear for NCLT matter, which I am waiting for coming. So maybe for just for 5 minutes, there may be a small interruption in between. So CI of the real estate companies are altogether a different ballgame, as you all are aware. At times, demand in real estate is slow compared to and the appreciation value at times have remained slow. Sometimes the investor find it difficult to procure even the break-even value, and if the company goes into insolvency, in that situation, surely uh, uh, the investor or the home buyers would like to get rid of the project by maybe, if possible, by taking the refund. Builder also lure the home buyers to make the upfront payment by giving them discounts or by offering return over their investment in the name of license fee, interest, etc., or offering them subvention scheme, unrealistic promises about their amenities. Real estate market is location specific, so we can't compare the value of one real estate project, say in Mumbai, with that of the Bangalore or in Hyderabad, or maybe in some remote places like Kolhapur or uh, maybe suburbs. So at times we also observe that there is a deficit between the home buyers, developers, builders, bankers, and the land development authorities and even the government authorities at times because of the uncertainties about the possession, delay in construction, title issues, etc., resulting in formation of the groups of the home buyers or home buyers association, and they start taking the legal proceedings against the promoter and developers, sometime in RERA court or in consumer court or sometime in IBC. Sometimes they even file criminal complaint or EOW complaint. There may be cases of check bouncing because the security or check might have been given by the builder. So sometimes the project has been cancelled by RERA. Sometimes GST procured by the builders from the home buyers is not paid to the government. Therefore they are getting the credit. The home buyers are not getting the credit of it. Sometimes the project is complete otherwise in all respect. The operational creditor OC is not been given, and hence the possession is not given. Sometimes the bankers don't give NOC for transfer of title because the loan is outstanding. Sometimes the home buyers are in the homes since the possession is given to the home buyers, but the title is not passed on to them. Sometimes the bankers threaten to declare the loan as a willful defaulter or the fraud loan or filing of the CBI or EOW complaints, and then the builder gets absconding. At times, the builder loses the value or reputation. He may even assign the rights to the third party, and another builder may try to another builder, and he may try to. At times, even when the home buyers obtain favorable orders from RERA or consumer court or refund, they're happy to see the favorable order, but reality checks happen when they start implementing the order. At times, the builders say that they have no money to pay the refund, even if order of RERA court or consumer court, and then the home buyer have to go back to RERA, who may at the most impose the penalty or start the prosecution with a which lengthy legal battle. At times, even if the builder has money to pay the refund as per the RERA order or consumer court, but they still don't honor the payment because if they pay one of the home buyer with interest, there will be line of all the home buyers going to RERA and consumer court, and the builder will then struggle with the legal battles and legal issues. At times, a builder does multiple agreement for the same property or flat, use the project funds of one project with another to another project, take consideration in cash. These are the main issues we face when you go through the CIRP. They don't disclose the bank, the sale of the flat, and consideration received from the home buyers. So that they have to repay the loan to the bankers. There also they can manipulate at times. Take consideration value from the home buyers in account of another entity or in personal name or in the name of the family members. These are some of the issues. Just to show the background, these are the issues that we face when the real estate insolvency comes. After background, now we'll go through what are the remedies that home buyers will have from the builder when this kind of default happens under law, under the IBC, and under various other laws, which are the remedies available. And then we'll move to the IBC. What are the challenges we face in the IBC? So, what alternatives are available to the home buyers? Under RERA, they have remedies. So, they can go to RERA court. The Consumer Protection Act, they have remedies. They can go to consumer court. Many times in the agreement for sale, there is arbitration clause. So, under Arbitration and Conciliation Act, they can appoint an arbitrator and try to resolve the issue through arbitration mechanism. There are also civil remedies available wherein after getting the order of refund or they may file a recovery suit, or if they want property, if it is already constructed, then suit for specific performance can be filed. In case of criminal remedies also, they also have criminal remedies to have the provisions about the cheating and criminal breach of trust under BNSS. And of course, IBC, the main topic that we are going to discuss, remedies available to home buyers under insolvency and bankruptcy code. If application is filed under RERA or consumer court, can one still go to IBC? Answer is yes. Can application for CIRP under IBC be filed by home buyer in case of default by a real estate company? Again, answer is yes. Home buyers can jointly file the application for CIRP and 7 of the IBC. However, यहाँ पे एक छोटा सा important point है that if delay in possession or default, you can say, or construction activity is because of some force majeure event, then the same cannot be considered as default, and hence the application for CIRP cannot be admitted in such case. In Navin Raheja versus Shilpa Jain and others, the NCLAD clearly held that if the delay is delay in possession of the real estate not due to the corporate debtor but a force majeure event, it cannot be alleged that CD has defaulted in delivering the possession. Section 5(7). Now we'll go through the financial creditors. What is financial credit? How home buyers are financial creditors? What is financial debt? And how home buyers can be considered as financial creditor? And what amendment that was made? What is the significance of that amendment? Section 5(7) defines the term financial creditor. It says financial creditor means any person financial debt is due owned and includes a person to whom such debt has been legally assigned or transferred to. Section 5(8) says financial debt means a debt along with interest, if any, which is disbursed against a consideration for the time value and includes any amount raised under any transaction, including any forward sale or purchase having a commercial effect of borrowing. Explanation was added thereafter by an amendment. So let's try and understand the explanation. For the purpose of this subclause, any amount raised from an LOT under the real estate project shall be deemed to be amount having commercial effect of borrowing. So it is a deeming provision which says that if you are an LOT of the real estate project, it will be deemed to have a commercial effect of borrowing and therefore covered within the meaning of financial debt. But what is here to be noted also is any amount raised under any other transaction, including forward sale or sale purchase agreement, having commercial effect of borrowing. So it doesn't limit only to the LOT of the real estate project. It also talks a broader sense under 5(8)(f). It says any amount raised under any transaction, if it has a commercial effect of borrowing, it will still fall within the meaning of financial debt and the creditor will be financial creditor. So it is not necessary that a person must be an LOT of the real estate project as defined under RERA. It is a extension narrowing down the definition. So that is what position was held in the Pioneer judgment, which is a landmark judgment on this. And this amendment was it was challenged in the Supreme Court, and a wonderful judgment. Those who are aware of the Pioneer and Urban Land Infrastructure Limited versus Union of India in the 2019 Supreme Court, wherein Supreme Court has observed that the definition of the financial debt is an inclusive definition. It is given in para 31 of the judgment. Second, it is observed that LOT who give advance to the real estate developer and thereby finance the real estate project at hand are financial creditor and not the other creditors. That is given in para, that was observed in para 43 of the judgment. What is the rationale and ratio of that judgment is that when the LOT gives the money, advance money to the real estate developer, it is just like how bank gives an advance and loan to the real estate company. Same way, the LOT also give advance to the real estate developer this money, and which has a commercial effect of borrowing, and therefore they are logically a financial creditor, and they are not falling under the category of other creditors. So they are not other not financial creditor or operational creditor. Therefore, they go to other creditor. It will not happen because it's in the category of financial creditor. Any amount raised from LOT under real estate project would in fact be subsumed within the section 58F, even with adverting to the explanation introduced by the amendment that is given in para 68. The explanation added through the amendment is clarificatory in nature. So what it says is the explanation is merely clarificatory. Even without that explanation, the LOT of the real project was covered under the broad meaning of 58F because it was dealing with any amount of any transaction of forward sale purchase agreement having a commercial effect of borrowing. So the emphasis implied is on the commercial effect of borrowing or on any transaction. So explanation is a deeming provision and not intended to narrow down the original interpretation of 58F. While interpreting section 58F, it is clear from any amount and any other transaction, which means that amount that is raised under transaction not covered by any clauses would amount to financial debt if it had a commercial effect of borrowing. That is given under para 65 of the judgment. So these are the ratio which was held in Pioneer Urban Land Infrastructure Limited versus Union of India and other very important judgment. If you want to understand what is financial debt and commercial effect of borrowing or time value for money, this is one of the finest judgment we have. Now, the said amendment is a provision and is intended to clarify the position of LOT as financial creditor. The clarity is brought by the said amendment. Any confusion rest that any amount raised from the LOT under the real estate project would be interpreted as having commercial effect of borrowing. In nutshell, the home buyers are financial creditors. However, that does not mean that an amount raised from one LOT under the project is not a real estate, cannot be covered within the meaning of having commercial effect of borrowing or as a financial debt. So as I said, just merely a person is not LOT covered under the real estate under the definition of RERA does not mean that he cannot be a financial creditor. He can still be a financial creditor, so provide the amount is raised under any transaction of sale purchase agreement and is having a commercial effect of borrowing, that is interest rate and all that. Provision to section 7(1). What it says, if you read, as we know that home buyers can apply for CIRP under section 7 of the IBC. That is given under provision to section 7(1). That application for initiating CIRP against a corporate debtor can be filed jointly by not less than 100 of such LOTs or not less than 10% of the total of LOTs under the same real estate project, whichever is less. So this is what is important is each project you have to consider this aspect. If you are filing in a particular project, you are having you have been allotted flat in a particular project, then in that respective project to consider this criteria of having either 100 LOTs or 10% of the total number of LOTs, whichever is less. Any decree holder of RERA or consumer court would be considered as an independent financial creditor and not the home buyers, and hence not hit by the ordinance of 28 December 2019. That is, by 28 December 2019 ordinance, this amendment was made about this 100 LOT and 10% criteria that was introduced by this amendment. So he need not fulfill this criteria if he is a decree holder. If he has already obtained the order from the RERA court or from the consumer court, wherein the liability to that respective financial creditor is more than 1 crore. Maybe one financial creditor or collectively, jointly. If they have obtained the order from RERA court and consumer court, where the liability is more than 1 crore for the default, then in that situation, they need not fulfill the criteria of that 100 LOT or 10% because they are not home buyers. They are financial creditors. So they are independent financial creditors. Even though they might have been allotted flat, but after getting adjudicated through the courts, RERA court or consumer court, they have been ordered for refund. So logically, they are a financial creditor. So I hope you understand the thin difference between this home buyer and the other creditor otherwise. So they just need to have liability more than 1 crore and they can file the petition for CIRP under section 7. Now I'll go through certain rules which are applicable. Rule 2AA, which define the word class of creditors. So what are the relevant rules now? Class of creditor means a class with at least 10 of such uh, under section 10 such creditor under section 21(6)AB, and the expression creditors in class shall be construed as accordingly. If there are more than 10 home buyers, they form a class. Similarly, if there are more than 10 debenture holder or deposit holder, they form a class. You all are aware of that. Section 4A, choice of AR. On examining the books of accounts and other relevant records of the CD, the IRP shall ascertain the class of creditors, if any. If IRP shall identify at least 3 insolvency professionals who are independent and eligible to be RP under section 3. So he should be an independent person and willing to act as a AR of the creditors in class. IRP shall obtain the consent of each IP in each of such 3 IPs in form AB. Regulation 4D, which was again introduced by amendment, which is very important amendment, operating separate bank account for each real estate project. Where CD has a real estate project, IRP or RP shall operate a separate bank account for each real estate project. Now it has a because later on when we discuss about the project-wise insolvency and all those things, where for each project a separate resolution plan can be sought or separate resolution plan can be made, so that the entire CD need not go into the liquidation if it is not possible to have the resolution plan entirely. Then it is possible to have resolution plan based on each project. So there it becomes very important that from you maintain a separate bank account and separate assets, liability, and other records of the each project of the real estate that respective CD. So this is very important amendment which was brought. Regulation 4E, handing over the possession. After obtaining COC approval of at least 66% of the total votes, the RP shall hand over the possession of the plot, apartment, or building or any instrument agreed to be transferred under real estate project and facilitate registration where the LOT has requested for the same and has performed is part of agreement. So LOT has made full payment. The performance is done from the LOT's part. In that situation, the IRP or RP has the power to hand over the possession of the plot, apartment, building, of course, subject to, since he has to act under the supervision of the COC. So COC's voting, of which 66% is required for any such decisions. Rule 6, public announcement. Public announcement shall offer choice of 3 insolvency professionals identified under Rule 4A to act as a AR creditors in each class. Authorized representative, one of them out of 3 IPs, one of them will be selected as authorized representative for the creditors in class, that is home buyers. Rule 8A, claims by the creditors in class. A person claiming to be a creditor in class shall submit the claim with proof to IRP in electronic form in Form CA. We all are aware of it. I'm just going through that fast so that we can give more time to the practical issues. The extension of debt due to the creditors in a class may be proved on the basis of the records available with the information utility or other relevant documents, including any agreement for sale, letter of allotment, receipt of payment made, or such other document evidencing the existence of debt. So these are the statutory documents which under law the home buyers are required to submit along with their claim, whatever documents they have. In addition to that, they have other supporting documents that can also be submitted. A creditor in class may indicate its choice of IPs from amongst the three choices provided by the IRP in public announcement to act as AR. So home buyers will choose one of the three IPs to act as a AR for them. So each home buyer will choose from the three home buyers one of the name of the home IP to act as AR for them. Section 21(6)(a)(b) says IRP shall make an application to the adjudicating authority along with the list of all the financial creditors containing the name of IP other than the IRP to act as a AR who shall be appointed by the adjudicating authority prior to the first meeting of the COC. So practically ये बहुत मुश्किल होता है अप्लाई करना है फर्स्ट मीटिंग ऑफ द COC के पहले to appoint a IP. Now, many times that question arises, definitely the person of IP who has been selected by majority. But वो 14 days के अंदर जितने क्लेम आए ही या उसके बाद और क्लेम भी आएंगे उसमें भी तो इलेक्शन होगा तो 14 days तक का टाइमलाइन आपको लेना. So within 14 days, whosoever has submitted the claim on whatever name has been suggested, that majority of the home buyers would have suggested someone's name or as a ER, that name has to be taken. Section 18(1)(b) imposes on the IRP to IRP as under. So this is about how the claims are required to be submitted under various forms. I'm sure you are aware of it. Operational creditor in Form B, financial creditor in Form C, financial creditor of a class that is home buyers, say for example, in Form CA, workmen and employees, Form D, if there are authorized representative of them, Form E, and claim by other creditors in Form F. Now, let's go through the practical issues. From here, what challenges we say once the claims are submitted, what challenges as an IRP we face in submission and verification of the claims, what challenges in real estate projects come. So many times, one single unit is sold to multiple home buyers, and such home buyers claim for the usually we accept such claim of all the home buyers. So what happens is, say one single unit is sold by the builder or the corporate to several home buyers, Mr. A, Mr. B, Mr. C, to all of them they have sold the same unit. It is possible. But then how to resolve it when it comes to the same unit, there are 2, 3 or multiple claims, then what happens in that situation? So in that situation, definitely we have to see whether the claim has been proper. First of all, the claim submitted is proper. We have all the evidences about the payment, about the receipt, allotment letter, all those things. If agreement for sale are also executed, then we have to call for agreement for sale also. All those which are available should be submitted. Thereafter, on verification, if we find that the claims are legitimate and genuine of all these people, then the who has registered the agreement for sale first, he shall be first given that flat or the unit, while the remaining claimant may be negotiated to have another flat, alternate flat from the unsold units of the project. Now, these things happen with the permission of the COC. RP or IRP should not decide of his own. So, but that discussion and negotiation should happen with the respective home buyer, that we cannot give the flat originally originally allotted to him because it was sold in prior to him. It was sold to someone else. So therefore, as a matter of discussion, negotiation, this can be discussed with the respective home buyer. He can be offered some other flat, if possible, from the unsold units of the project. And these things has to be placed before the COC. And it has to be decided and approved by the COC to have this kind of solution. If it is not possible, let NCLT decide it. Where there is no unsold flat, it is possible that with the permission of the COC, he can be considered as a refund holder. He may be asked to take the refund of the money, and instead of giving him a unit, if it is possible to give the refund, which is acceptable to home buyer and the whole COC, then that alternative can also be considered. If it is not possible, as I said, the ultimate solution goes to the NCLT then. During CIRP, does RP have power to continue the construction activities, power to hand over the possession, power to transfer the titles, power? Yes. RP has all those powers and can take the home buyers from the list of creditors once the possession is handed over to the claim. It can take out the home buyers from the list of creditors if the possession is already given to him. If all the activities are done now, care is to be taken that RP should not give possession where the transaction is incomplete. If the construction activity is done, OCCC is obtained, only possession is left while all the consideration has been received, agreement for sale is signed, all the transaction is otherwise complete in all respect, only then the possession can be given by the ARP or RP. And of course, that is to be brought to the notice of COC. But once that possession is given with permission of COC, this particular things, the claimant whose claim might have been originally admitted, that claim can be removed from the list of creditors. And an allottee of the flat who may have a registered agreement for sale, but still who can show the proof, who may not have registered agreement for sale, but can still have made the payment and can show the proof of payments. He has also allotment letter and other supporting documents of the financial creditors of the class. Can such allottees claim be admitted? Answer is yes. Even if he has the registered agreement for sale, but he has other documents to reveal and reflect that the flat was allotted to him, there was a proof of payment by him, receipts are there, allotment letter is there, bank statement which shows the payment is made by him. So in that situation, his claim can be admitted. Now another type of transaction we come across in the real estate insolvency, where suppliers or services of the project are allotted flat. So builders have allotted flat to the say carpenter or electrician who has performed the work during the project. Now, because builders don't have liquidity to pay them, instead of making that payment to electrician's bill or carpenter bill, what they do is for the services they allot them a flat. Now, logically, this is under IBC. It is not well taken because it converts an operational creditor to a financial creditor. Logically, if a person is providing goods or services, he is operational creditor. But when he's allotted flat, he is a financial creditor. In a way, we'll also discuss later on how it is secure financial creditor. So when you are a home buyer, one of the very important thing, probably you are a secure financial creditor. So you are converting an operational creditor to a financial creditor. That changes the entitlement and the priorities are given, preference is given in payment. So now in such case, we may consider that kind of transaction as a preferential transaction, possibly under section 43. So do remember that we are not adjudicating authority. As IRP or RP, we are not the adjudicating authority and we cannot adjudicate the transaction. So as an IRP or RP, what we can do is we can apply to the NCLT for declaring this as a preferential transaction. However, what happens to the claim? Claim is required to be at the very instance until the order comes from the NCLT about the preferential transaction. So RP will admit the claim and make them a part of CIRP or the COC and then file application under section 43 to declare such transaction as a preferential transaction. Similar transaction also see when unsecured loan is given. Loan is given by the investor or high net worth individuals, HNIs, who fund project with understanding that in case of default by the corporate debtor, the unit or flat will be given to them in lieu of the repayment. You might come across a situation in many real estate projects. We see this, that against the loan given by the investor, the flats are allotted. Now again, this is an unsecured loan transaction unless there is any security created. So unless they have any proof of security, etc., it is an unsecured transaction, unsecured loan transaction. It is getting converted to the home buyers, which logically in a way is a secured creditor. Hence, the entitlement are upgraded. So just like how it was for supplier of goods or service, it converted from operational creditor to financial creditor. Here also it's a financial creditor, no doubt. He is an unsecured loan, but the priorities will change. The entitlements are upgraded because from unsecured loan, it got converted into a secured asset. So hence the entitlement are upgraded. Hence it may also be viewed as a preferential transaction, and the IRP has to follow the same process. That is, the IRP has to admit the claim, of course, as a financial creditor, and then make an application to NCLT under section 43 to declare the transaction as preferential transaction. Many times the mortgage or second mortgage is created. Sometimes what happens, some of the people give unsecured loan, and due to liquidity crunch, the lender do not even get the interest, etc. So at times the builder under pressure of them, few units, allot them few units to such unsecured lenders. That can be considered as preferential transaction. This is because the home buyers have better rights compared to the unsecured creditor. So as per the definition of security interest under IBC, home buyers are secured financial creditor, having rights over the having right of the specific performance based on agreement for sale, and also the right and interest over the relative FSI. So unsecured creditor is upgraded to the home buyer, is a preferential transaction, which should also get reported to NCLT. However, their claim should be admitted initially. Now, when the bank loan is given to the corporate debtor against the whole project land or the project asset, later on the corporate debtor creates further mortgage for with the another bank by mortgaging few more units without taking NOC from the first bank. So in that situation, what happens? Logically, the second mortgage created because NOC is not taken from the first bank. That is a technical glitch on that, because in the same another second mortgage is created. So logically, how we can consider this as a second bank or second mortgage created or second charge is created over the respective project land without NOC of the first bank. Units allotted against the consideration in cash. Now I am talking of the cash components. Many times in real estate projects, we come across a situation, the home buyers or LOTs claim that they have paid consideration in cash. Many times they submit such claim where they show that this much cash is paid in whatever form CA they have submitted. And there the technical glitch sometimes arises that such things are not recorded in the books of accounts sometimes. So for IRP or RP, this becomes a very challenging thing, that how to deal with this situation. Do they have any proof? Do they have, should IRP or RP merely rely upon the books of accounts, or IRP or RP should look into the other document evidences as well? So we'll deal with both the situations. The first situation, units are allotted against the consideration in cash, recorded in the books of accounts. In that situation, it's a simple situation where the LOT claims that I have made payment in cash, and they have submitted all the relevant documents which reflects the payment was made in cash. Say for example, they've got the receipts, they've got sometimes got MOU, sometimes they've got email correct communication, sometimes they've got confirmation of accounts. wherein cash component is accepted by the corporate data, the counter entry in the books of accounts of the corporate data is also reflecting. So if it is recorded in the books of account, in those situations, the claim can be accepted, especially where the requisite cash receipt is submitted. Many times such cash payment, now why this cash payment is made? कहीं ये cash payment करके क्या फायदा है? So of course these are all not very taken well by the judiciary also. When made in cash, definitely it has an impact on the revenue, because you are hiding and concealing the transaction value. You are undervaluing the transaction. Whether this can be considered as undervalued transaction is a subjective thing. But you are not showing the cash component to the judiciary, and you are saving stamp duty on that. You are saving GST on that, because you are paying stamp duty and GST on the reduced value without showing the cash component. Similarly, even the income tax by the corporate debtor will also get reduced if it is not reflected in the books of accounts. I've also come across a situation, many real estate company or the corporate debtor maintain two parallel books of accounts. That is also a challenging task. In one book of account, which is available to them only, which is not reflected in the income tax or anywhere, there they mention about the cash component. Whereas they also maintain a separate parallel books of account where cash component is not recorded. And those records are shown to the income tax authority, GST authority, etc. So the basic objective is to reduce the stamp duty, GST, tax, all those things. However, as an IRP, when we are verifying the claim, we have to see if it is possible to establish the payment made, the consideration value, and the claim is genuine. In that situation, it should be accepted by IRP or RP. Otherwise, it should not be accepted by IRP or RP. So where the cash is not recorded in books of accounts, and the cash receipt is not that of a normal receipt issued by the transaction of banking channel or the check payment. What happens in this kind of transaction where part payment is made in check and part payment is made in cash. So we have to see that which is issued to the to the LOT for check payment, whether the similar receipt is issued for cash payment as well, or it is some different way of issuing the receipt. Sometimes it is not on the letterhead, sometimes it is not on the proper document, just MOU is executed. So all those things are to be looked into, whether proper receipt is there. If the same receipts are issued, then, but it is not recorded in still in the books of accounts, then you have to see all the collaborative evidences that whether such transaction can still be considered or it cannot be considered. Just merely it is not reflecting in the books of account, that does not mean the transaction is not correct, because books of account may have been manipulated. You have to see all the evidences and supporting documents. There was a judgment also on this. In the end, I'll give you the judgment name. I'm not having right now here. So there is also a judgment which was discussed on this particular point, wherein the NCLT has held that the RP is not required to merely and blindly rely upon the books of account, because books of account can also be manipulated. Therefore, what the role of the RP is to verify all the documentary evidences, examine all the documentary evidences, supporting documents, and then see whether the claim can be admitted or not. Many times, even the cash book are sought by the RPs, IRP, RP. So all these collaborative documents are to be looked into. So what I'm trying to say is the merely books of account is not the conclusive evidence. You have to see the other documents as well, collaborative documents. But another challenge also comes if there is a genuine cash transaction. The next question arises that where is the cash amount? If it is not recorded in the books of account, then it is the duty of the IRP or RP to chase that cash transaction or the cash amount from the promoter or director who has given the receipt or issued the receipt. So the necessary application for fraudulent transaction may be filed in the Honorable NCLT for that. Where there is a decree holder of the RERA court or consumer court, they are independent financial creditor and they are not home buyers, and therefore they are entitled to the interest as given as per the decree that is adjudicated upon and not as per 8% interest rate applicable to the home buyers. Many times you come across a situation that home buyers submit the claims in Form CA. At the same time, they also claim higher interest rate, showing the decree or order of the court, decree of the consumer court, RERA court, wherein they say that I am being awarded with the interest rate of 12% or 16% from the RERA. In that situation, first of all, he has to submit the claim not in Form CA, it should be submitted in Form C as a financial creditor, independent financial creditor. He is no longer a home buyer. And he can claim interest, whatever is adjudicated upon him. So, as per the decree, whatever interest rate is entitled to, he will be entitled to. And not necessarily he should be given 8% interest rate as given under Regulation 16A for the other home buyers. So, where the claim of the LOT or flat booking is cancelled. Now, this is another challenge we see sometimes, that LOT or home buyer have cancelled the booking. There are two possibilities. Either he has cancelled it with due process of law, or he has cancelled it without following the due process of law by the builder. So, sometimes as a matter of penalty or in coercion with the home buyer, they cancel the booking. Now, in that situation, if it is mere, if the due process of law is not followed, and if the cancellation is illegal or invalid, in that case, the LOT can still we can still consider to admit the claim of the LOT if he is ready to pay the remaining amount or the consideration. However, if the claim of the LOT has been, the booking of the LOT is cancelled with due process of law, and the refund is not yet by the corporate debtor or refund is not given by the corporate debtor, then his claim should be considered as a refund holder and not as a LOT or a home buyer, because it is cancelled. Booking is cancelled. Another thing, sometimes the money is transferred. The LOT is transferred from project A to project B. So when the corporate debtor have multiple projects, many times it happens that the home buyer or the LOT is transferred from one project to another project. It means they are allotted units in another project against many times the unit of the earlier project, or many times against the loan also. So you have to see in that situation, again, two kind of possibility. One, where the money is also transferred. So say Mr. A is transferred from project A to project B, and unit is allotted in project B instead of project A. So when corporate debtor has project B, if the money is also transferred to that particular, then such claim can be accepted. But if the money is not transferred to the corporate debtor, in that case, the claim should not be accepted. Of course, if the both projects are with the same CD, then it is fine. If both the projects are held by the same corporate debtor, and it's just a journal entry or ledger entry which is required to be passed, and the respective agreement for sale is properly made and other documents are in order, then you can. Usually, since the home buyer uh, pay the EMIs to the bank. Now I am coming to the case where home buyers take a loan from the bankers and then they invest it in the real estate project for allotment of flat, etc. They purchase the flat or a unit, and later on that home buyer defaults. Then what happens to the bankers? And whether bankers also have right to claim over that corporate debtor, real estate company which goes into bankruptcy. So here I am talking of default by two people. One, where the default is made by the home buyer to the banker, respective banker. Second, default is made by the real estate company, that is a corporate debtor, by not giving possession in time. In that situation also, how the situation arises, company and the corporate debtor is under the insolvency. So many times the claims are raised by the bankers. So whether those kind of claim can be accepted and admitted, in that situation, CIRP or RP, we have to see whether there is any tripartite agreement with the bankers. So is there any agreement between the bankers, builder and the home buyer? If there is a tripartite agreement there, in that situation, you also have to see whether banker have right to take away the possession of the home buyer. That is right of subrogation under DOPA. Under the doctrine of subrogation, do they enter into the shoes of the home buyer in case of default? And then you have to see whether there is a default. So this is very important thing where banker claims to the corporate, whereas home buyers are also making the claim. Then whom should be given that respective claim? So usually home buyers have to pay the EMI with the bank. The banks are comfortable even if the builder delays or does not give possession of the flat in time. At times, there are tripartite agreement. At times, there are tripartite agreement between the bank, home buyers, and builders, so that the builder also have some responsibility in case of default. What responsibility the builder take is that in case of default by the home buyer, the possession of the property would be given to the bank and not to the home buyer. And the interest would be recovered from the margin money which is paid by the home buyer. So the home buyer loses the money given to the builder, while the bank gets the possession of the property as well as the interest partially from the builder. In such cases, the bank also filed their claim CIRP because they have entered in the shoes of the home buyer under the doctrine of subrogation. At times, major portion is paid by the home buyer, say rupees 60 lakhs, and remaining is paid by the banker, say 40 lakhs. Both makes the claim to the borrower as a borrower defaulted, and there is a tripartite agreement. Then both the claimant would be admitted. Home buyers would be admitted for the claim of 30 lakhs, while the bankers would be admitted for the claim of 40 lakhs. So they both will be admitted so far as the claims are concerned. Let us file the claim with corporate debtor only when there is a tripartite agreement, else there is no privity of contract between the bank and the builder. Second, tripartite agreement should allow right of subrogation to the banker on certain triggering points like loan is defaulted and declared as NPA. So the triggering point is very important also, that in tripartite agreement, when the right of subrogation will be exercised by the bank, that in that the default by the home buyers or the loan is defaulted, it become NPA. Those are the triggering points. Now, angle section 58D of IBC. Why we need this? Many times the development authority claims as a financial creditor, say MIDC or some other land development authority. They have given the land on lease and on the lease to the builders or corporate debtor. So in that situation, when they make the claim for the lease, claim as a financial creditor. What sector? Section 58E of the IBC says the amount of any liability in respect of the lease or hire contract which is deemed as a finance or capital lease under the Indian accounting standard or such other accounting standard as may be prescribed, and it is a financial debt. We all know section 58 deals with the financial debt, and in that, if it is a financial lease as per the Indian accounting standard, it will be covered as a financial debt. And if it is not covered within that meaning of financial lease under Indian accounting standard, in that situation, considered as operational lease. In that case, it will be operational. Most of these land development authorities submit their claim in form of financial creditor. As per 5D, the lease agreement can be considered as financial lease as per the Indian accounting standard. Only then the creditor would be considered as financial creditor. Else, it is not financial creditor. These can be considered as financial lease if it transfers substantially the risk and reward to the ownership of the underlying asset. So, how will you determine whether there is a financial lease or operational lease? As per Indian accounting standard, if the risk reward ratio or risk reward of the ownership is passing to the lessee ultimately, then it is considered as financial lease. For example, the lease transfer owner transfers the ownership of the underlying asset at the end of lease period. So, for example, lease is for 99 years, and thereafter the lease passes on to the ownership is passed on to the lessee. They have right to acquire the land. So, lease agreement carrier right to buy. Lease agreement carries right to buy the land at much reduced price. So these are some of the instances where you can consider is a financial lease because it transfers substantially the risk and reward of the ownership of the property. Without fulfilling these financial lease criteria, it will be considered as operational lease and the creditor will be operational creditor. Few relevant judgments have given that Concord Infra Private Limited versus Shubhkamna Builders Private Limited versus Noida Industrial Development Authority versus Anand Sonbhadra RP. As per section 58F of IBC, LOTs or home buyers are financial creditors. Yeah, I think I missed that. Yeah. NCLT Mumbai observed and held for this Rent Development Authority one of the recent judgment of 2024, 14th October 2024 judgment, wherein NCLT Mumbai observed sorry, I think I missed one slide in between. Yeah, so now we'll be discussing about the how home are secure financial creditors. Now, this is one of the very gray area in a way that when company goes into or the corporate debtor goes into liquidation, everyone say that the home buyers are unsecured creditors and they fall in that category of 53D and all. But if we go by the spirit of it, if we go by the principles of law, probably home buyers are the secured financial creditor. Of course, there is a now one judgment also which deals with it, but it does not analyze this in detail. But still, I think what are the law I would like to share with you. As of now, this position is still to be determined by court probably. Secured creditors, as per section 58F of the IBC, home buyers are the financial creditors. We all know that. Secured creditors means a creditor in favor of whom any security interest is created. Section 3, subsection 30. Security interest definition. Another definition, as per section 3, subsection 31, security interest means a transaction in which secures payment or performance of obligation. Section 3, subsection 35 says that transfer of property means a transfer of any property and includes the transfer of any interest in the property. Section 55(6)(b) of the Transfer of Properties Act provides that agreement for sale creates right of the home buyer in the property. So sale transaction, when you enter into an agreement for that creates right of the home buyers in the property. What rights it creates? It creates a right for specific performance of the contract, and it also creates a right and interest to the relative FSI of the land. And indirectly, it's a creation of the charge on the property. And therefore, in my view, the home buyers with whom a proper agreement for sale is registered, which is duly by the home buyers, then they are secure financial creditor, which creates an obligation on the CD to deliver the possession of the flat or unit. Because this agreement for sale, which is executed, it creates an obligation on the corporate debtor to deliver the possession of the flat or unit. It is a performance of an obligation under which is covered in the definition of security interest. Okay, so when you this definitions, security interest, transfer of property, read with the agreement for sale under the Transfer of Properties Act, then this position emerged provided, of course, there is a caveat that this should be a valid, there should be a valid agreement for sale registered with the, and secondly, the LOT should have performed his part of the contract. So, home buyer should have made point of consideration in time. All these criteria are met, receipts are there, proper payments are made. In that situation, the agreement for sale is valid and binding on the corporate debtor. Logically, they are a secured financial creditor. Of course, this in a home buyer should fight the position from the beginning that they are secured financial creditor and they should be considered as such if required. Go through the NCLT process adjudication. Because now if the company, for God's sake, it goes into liquidation or something, the home buyer position becomes very important. If they are unsecured, their position is very vulnerable for the payments which they have made. If they are claimed as a secured creditor and adjudicated as a secured creditor by the NCLT, then it goes into liquidation also. Then they will have right to stand along with the secured creditors under section 53(1)(b). So therefore, in that case, the whatever real assets are realized, they shall be uh, proportionately divided between the home buyers and the secured creditors. Otherwise, what happens in case of liquidation, the project land would be sold off, and some third party, maybe third party buyer, whosoever acquires that land in the liquidation, they will take it without any obligation or liabilities. So therefore, there the rights of the home buyers will get vitiated, and therefore it is necessary that home buyers claim as a secured creditors. Generally, even RP should take care to protect the interest of stakeholder, including the home buyers. And therefore, if the resolution doesn't work out, then even at the liquidation stage, RP should first try to sell CD on going concern basis so that home buyers' interest to that extent can be protected. In that case, this is very relevant section which was passed by NCLT on 14th October 2024. So what NCLT Mumbai observed is judgment relating to redevelopment project. In this, what happened is there are resettlers, that is those who have given land to the land and building, that is societies are under redevelopment, and the project is of redevelopment project, and there are few flats, additional flats are units are sold to the third party buyers also. So fresh units and flats are sold by the builders. So they are home buyers. At the same time, there are also resettlers. So those who have given their land for redevelopment. So in that case, what the NCLT has observed, section 331 of defines security interest to mean right, title or interest or claim of property created in favor of or provided for the secured creditor by transaction which secures the payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance or any other agreement or arrangement securing payment or performance of an obligation of any person. The emphasis is supplied to any other agreement or arrangement securing the performance of an obligation. That is where the agreement for sale would fall. And further in para 3.10, what court has held is, in view of the above, we hold that a resettler, so those who have given their flat for redevelopment, they are resettlers, are to be classified as secured other creditors, since they had given the redevelopment right to the land and the building in lieu of the specific flat, as they can neither be considered as financial creditor nor financial creditor under the IBC. So position of resettler under redevelopment project, it is very clear that they are other creditors, but secured other creditors, because they also given their flats for redevelopment. So with them, there is a performance obligation through development agreement. So therefore, they also have right, they are also secured creditors, but other creditors. They don't fall within the category of financial creditor because there is a lack of commercial effect of borrowing. and the home buyer from unsecured financial creditor to secured financial creditor. So here the NCLT has this is main judgment, first judgment where the NCLT observed that the home buyers can be considered as secured financial creditors. But since it is settled by the NCLT level, maybe at Anclet and Supreme Court level, this position need to be first. Now, many times we come across a situation where possession of the flat is given to the home buyers. Another challenge we face, many projects are complete and possession is given to the home buyers. Now, there are two possibilities. One is the projects are complete or almost on the verge of completion, but OC is not obtained because project is not completed, OC and CC is not obtained. But still the possession to the home buyers in the haste that company is going into CIRP. To evade the CIRP, the possessions are given. In that case, probably that is illegal possession, and claims are required to be admitted in the CIRP and they should form part of the COC. But there is another situation where the transaction is complete in all respect. So when the transaction is complete in all respect, consideration has been paid, agreement for sale is made, possession is given, all these things are done, and in that situation, if the possession is given to the home buyers in due process of law, and then they need not be forming part of the CIRP or C, their claim need not be accepted. The transaction is complete. So these scenarios you have to see. Many times there are challenge arise, possession is there, agreement for sale is not there. So that is again an incomplete transaction. That's not a complete transaction. Possession many times is given in haste just to get the CIRP. In that case, they are the home buyers whose claims are required to be admitted. So we'll just go through that. Many times we'll come across a situation where possession of the flats are already handed over to the home buyers. They would logically not fall within the meaning of the payment if the possession is legal, transaction is legally completed in all respect. Like agreement for sale is registered, consideration value is paid in full, OC and CC was received before is given, etc. And hence no further claim of the home buyers lies on the corporate debtor because the transaction is complete in all respect. However, we also need to see that none of these transactions are preferential transactions. At times they are given in preference to the other creditor just to the flat. In one of the CIRP, we had seen that where I was a AR in that particular CIRP, where the funds were allotted to the promoters. What happened? The possession was given to some of the home buyers who had made a payment also, probably full payment made, but the home buyer said he had paid the full payment, certain consideration were paid in cash, etc. But then the rest of the flats which were unsold, so it's actually unsold inventory of the corporate debtor. What the corporate debtor did, or the promoters of the corporate debtor did, they allotted those flats themselves in the name of the promoter or the family members of the promoter. And then they also gave those flat on the license basis. So when the RP took the of the custody of the assets, these flats were considered, he thought that probably these flats were sold. But when he checked the record and everything, this allotment was made by the real estate company to, that is corporate debtor, to the individual promoters of the corporate. And when he sought the payment, there was no proof of payment. So some 20 flats which were actually an unsold inventory of the corporate debtor was allotted merely by issuing the allotment letter in the name of the builders or the family members of the builder. So these kind of things you have to be careful about. These are all fraudulent transactions. Necessary application can be filed for those transactions when you don't see the consideration. But if the possession is illegal or unauthorized, say OC or CC is not received by the builder, but still the possession is given to the home buyers to avoid the CIRP. Basically, the possession is illegal or unauthorized, then the claim of such home buyer should be submitted, collated, examined, and verified. And subject to the direction of NCLT, the same can be admitted or be kept under verification until such further direction is received from the NCLT. Though one can always argue that OC is not received by the CD for the reason attributable to CD. How can home buyer be penalized for that? Be forced to become a part of the CIRP. Principally, the defaulter cannot benefit from his own default or the negligence. There was a judgment where one of the case where I was fighting in Mahesh Chandwani's case, I think it was Aristo developers matter, or Bonanza, I'm not sure, but in those cases that had happened, that OC was not produced. Now OC is required to be obtained by the corporate debtor. Rest of the whole transaction is complete in all respect. Entire full consideration was paid, possession was given to the home buyer, but OC was needed. Now in that situation, logically, since OC is not there, the possession is illegal. But the counter argument that was made by Mr. Chandwani was that OC is required to be obtained by the builder. Then why should home buyer suffer if he has not obtained OC? That is a mere technical lack on his side. Just like how it is required to be obtained by the builder from the bankers. If he does not obtain the NOC, that is not the fault of the home buyer. It is required to be done by the corporate debtor. If it is not done earlier by the corporate debtor, probably it will be done by the next resolution applicant. Just because he is not dead, that does not vitiate the title as such. So that is different ball game altogether. When OC is not there, the possession is illegal. And therefore, in that situation, such home buyer should be forming part of the CIRP or should form part of the COC. Claim should be admitted. Where possession has been given, stamp duty has been paid, but the agreement for sale or conveyance is not made, executed, or registered. So title is not passed because the project is mortgaged to the lender or bank and the lender has not given NOC also. So in that situation, what happens? Again, since the transaction is not complete in all respect, sale agreement for sale is not executed. So in that, just merely having possession does not pass on the title. So then in that case also, the claims we usually admit. As per section 17 of the RERA, title is transferred only with the registered agreement for sale or conveyance is made so that the stamp duty is paid. Secondly, the possession is given. These two things are important. And when it comes to IBC, you also have to see that consideration has been fully received. That is also equally important. So builder has removed it. So when these two things have happened under RERA, the builder has removed it from the inventory and the books of account, but NOC of the lender is not up, which is a technical requirement, and hence the claim are not accepted and do not form part of the COC or CIRP. Anyways, the NOC is required to be obtained by the CD builder as the home buyer has no privity of contract with the lender. So banker से जो NOC लेना है वो builder को लेना है, वो उसने नहीं लिया है तो you cannot hold कि वो title पास होने से रोक नहीं सकते. वो that's a technical glitch. And in that situation, such home buyers or allottees need not form part of the COC or CIRP because that transaction is considered to be over. It's mere lack of technical requirements that will be fulfilled by the next resolution applicant. At times, under the pressure of the home buyer or to avoid the dragging buyers into CIRP, builder give illegal possession. For possessions to be given, builder must have OC and CC. Then possession is correct. If OC or CC is not, and just to get rid of the CIRP, possession is given to the home buyer, the same is illegal possession, and home buyer's claim are to be accepted and be included in the CIRP or COC. As I said in one of the transactions which I was handling, the entire building construction was completed, water connection and all those requirements were properly fulfilled. The possessions were given in haste by the corporate debtor, but OC was and CC was not obtained. Even the consideration, some of the consideration value was outstanding. Now that consideration value, home buyer said that we have paid to the builder because the company was going into insolvency, we have paid it in cash. Whereas the builder has not reflected in its books of accounts. In that situation, again, the transaction is not complete in all respect. The possession without OCCC is incomplete. Some of the home buyers were not even having the agreement for sale in those transactions. and the rest was when the consideration was not fully paid. So, in my view, that transaction is not complete. Even if the possession is there, the possession is illegal. So, if there is a confusion, it is better to obtain the order from Honorable NCLT on this aspect, on this particular transactions. This can be considered financial fraudulent transaction if the cash has been paid, or home buyers can establish or prove that they have made certain payments in cash to the promoter of the corporate debtor, and the RP should also chase that cash consideration. Now, home buyer took a valid possession of the property. Home buyer also have agreement to sell registered, and consideration value and stamp duty is also paid. For passing the title, there is also that if the charge is registered by the banker on entire property and the bank is not giving NOC because of the default by the, while inventory is taken out from the books of the builder. In TOPA, it will be considered as part performance of the contract. The problem in the title in that is the NOC of the banker is not there. So NOC is not obtained from the banker. Many times the home buyer also take power from the builder that they would be having power to sell the property. Hence, the home buyer may even probably sell the property through the power of attorney holder, but it's not a freehold property. He can sell it subject to the mortgage of the bank. In such case, they would logically be considered as claimant of the CIRP, as the transaction is it shall not be considered as claimant of the CIRP, as the transaction is anyways completed, and only thing remaining is that of the NOC of the banker. So that does not stop the title from passing. That is a technical thing that is required to be obtained by the builder, the corporate debtor. If they have not obtained it, the new resolution applicant will obtain the same and pass on the title. So they don't need to form part of the COC or the agreement. Now, exclusion. Which project can be excluded from the CIRP, or what popularly is known also as reverse CIRP, or some people also call it as project-wise CIRP. So let's try and understand that where this kind of situation arises when real estate company or the corporate debtor has more than one project, and some of the projects are sound and they are not insolvent project, they are solvent, while the other are having defaults. In that situation, those projects which are solvent and progressing properly, they need not be necessarily dragged into CIRP, and therefore, for those projects, exclusion can be sought. Most of these projects is done properly and almost on the verge of completion with proper due compliances, then those projects can be excluded. Only those projects which are not under default can be excluded. But if there is a default, it would need to be resolved under the CIRP, irrespective of the fact that the land is owned by the corporate debtor or redeveloped by the corporate debtor. Sometimes it happens that land is owned by the corporate debtor, sometimes they only have development rights. In either case, if there are allottees or home buyers with whom the agreement for sale is executed, the consideration value is received by the corporate debtor, but the project is delayed or the possession is not given, these are covered under the default. So these are the default. Projects are delayed, possession is not given, default is made in payment of loan, all these things. There are possibilities where most of the projects of the CD are on the verge of completion, and those home buyers are not willing to file their claim. They are very confident that they will get the possession in next few months, or the promoter are also hopeful to complete the project in time. In certain projects, most of the people are already staying, but some of the flats are not yet handed over to the home buyers, or some of the facilities are not yet made, etc. Those home buyers probably need not be dragged into CIRP. However, the difficulties would be faced by IRP or RP to identify the project-wise inventory, material, equipment, vehicle, loans, advances. So if you do divide this project-wise, it becomes very difficult. identify that. So what happens, how to take the custody? Say for example, CIRP is definitely filed against the CD, and thereafter, after CD, uh, the court has passed the order for exclusion of certain projects. Definitely by that time, IRP would have already taken the custody of assets. But how will they segregate those project-wise inventory, those project-wise material equipment? It's a tedious task. So in those kind of situation, IRP should take custody of only those assets which are separable and keep watch over the rest of the common assets. Assets which are used commonly, vehicles, equipments, those things probably may be used for all the projects. So there also IRP need to keep track on that, because that particular project that will be utilized, there is order of the court to exclude that particular project from the CIRP. So things that can be segregated or separable relating to that project need not be taken custody of. Where few projects are doing well, while the other projects are under default, it is now well settled. Yes, Goti. Queries?
Sorry, nothing.
Okay. So where few projects are doing well and few projects are under default, well settled law that those projects are under default and not whole company should go into CIRP. There are many judgments, unsold properties, initial stages, where one project is under default, only that project will go into CIRP. But yes, if while filing the application is required, we file against the company for CIRP. So entire CD corporate debtor will go into CIRP company and then apply for the exclusion. Can Home Buyers Association be allowed to construct, or the resolution plan be submitted by the Home Buyers Association? Answer is yes. They can submit the resolution plan. They can take over the CD or the respective project. They can apply for exclusion of the project. I think in one of my case where Nirmal Lifestyle, there we had got the successful order for exclusion of the project. Reverse CIRP judgment. So relevant, there are few very important judgments on this. The first initial judgment was on the Flat Buyers Association Winter Hills versus Umang Realtex Private. So this is one of the very important judgment where NCLAT had innovated or created this reverse CIRP mechanism, where project was almost complete. The same can be excluded from the CIRP. That was a position held. It was further confirmed by the Supreme Court in case of India Bulls ARC Limited versus Ram Kishore Arora, director of the Supertech, order dated May 23. This Flat Buyers Association, what was the story was like this, that the city went into CIRP. One of the project was complete in all respect. It was on the verge of complete. At the same time, even the promoters of the corporate debtor was willing to complete that project. They wanted to bring certain funds to complete the project through one of the bank. I think JP Morgan was involved in that. For financial institution, it was a condition of JP Morgan saying that whatever financing is made for completing the project, that shall be considered as interim finance, and that shall be paid in priority to the creditors. So that was the condition where NCLAT approved that kind of thing, that to exclude that particular project to get this financing done through interim finance, and the project should be completed and hand over it to the home buyers. It was one of the finest judgment in where the CIRP, reverse CIRP was identified. Pankaj Mehta versus Ansal High Tech Township Limited, order dated 1st April 23. At times, there are many projects under one CD. If one of the project is under default, then only one project of the C should undergo CIRP. So, project-wise CIRP or reverse CIRP mechanism is important. Now, what are the criteria on what basis the court will decide the possibility of the reverse CIRP? The ratio of the judgments, it says that in a nutshell, reverse CIRP is possible only where construction is near to complete, the funds are available, or if required, additional funds are as I said, with JP Morgan in Umang Realtek was made. And such funds can be considered as interim finance, as was in Umang Realtek Limited, Private Limited. Funds would be utilized for completion of the project and handover to the LOTs would happen in specified limited time. Within a specific time frame, they will complete the project because it's just on the verge of completion. During the CIRP itself, the project can be completed and handed over to home buyers. Now, in certain transactions, we also see the presence of joint development agreements. So there are more than one developers. One of them is a corporate debtor or all of them under insolvency. So in that case, what happens? So one of the developer will do the development work, whereas the other developer will bring the land and give the development right to the other, and the other developer will carry out the development of the project and sell the flats into it. And then they share the revenue, 30% sharing, 20% sharing, that kind of sharing is there. So those kind of transactions, if the corporate debtor, one of the corporate debtor goes into insolvency, say for example, the corporate debtor under doing the construction activity and development work, who has right to develop the project, undergoes the CIRP. Then what happens to that other developer, the partner? They can submit their claim as an operational creditor. Now this is very interesting position. They are providing their right to develop against the consideration of the land and the land against the consideration. So it's an operational debt. Is given as an land. The land is an operational debt. Sorry, the right supplied by the owner under the joint development agreement to develop land is an operational debt, as the as its owner has supplied the right to construct or right to develop the land against the consideration. Claim of the owner would therefore be considered as that of an operational creditor. For example, land owned by a limited owner is given for development to corporate debtor, which is now under CIRP. Further right to sell is given by the corporate debtor to some third party. In such case, the joint development holder or the owner can be treated as operational creditor, as he has offered the land against the consideration. So this is one scenario. Another scenario, at times we have also seen that there are two or more companies come together, they engage into joint agreement, and they jointly develop the project, they jointly sell the property, and then they have revenue, all that thing. So they jointly do all that thing. If there is a default in those situations, then it's default of both the companies. So when there are multiple companies jointly developing the project or jointly involved in the construction and development and selling the property and bringing the land, in that situation, CIRP is required to be filed against both of them. Of course, also it is possible to have collective CIRP. And both, it is not feasible to have separate CIRP for both the companies because the claimant home buyers would be for both. So it is always better at the direction of the NCLT to conjunct both the CIRP and collectively have the CIRP collectively. At times there is one project which is under default, which is two or more companies through joint development agreement. In such case, whether all such respective two or three companies should undergo CIRP resolving the project, answer is yes. What if the joint venture partner owns the land, does not file the claim? They own the land, they have given you right to develop, but they are not filing their claim. In such case, RP should provide this information in the information memorandum, because this is the information can be taken for or the books of the corporate debtor. Like in many times, income tax authorities, GST authority are not filing their claims. It has always been held, many cases, if the books of accounts are available, RP should take the information from the books of accounts and include it in the information memorandum. And that should be with the resolution plan. RP should take such information from the books of accounts and include it in the information memorandum. Now, coming to information memorandum and resolution plan, what are the important thing we need to take care while we this real estate insolvency? The information memorandum should adequately cover the details about the claims pertaining to possession of the claimants, multiple allotment, refund claimants, uh, etc. Also, claims of the joint development partners or land authorities these things are to be highlighted. Similarly, the position of the subdivision land allotted or leased, if any, amount of the balance consideration to be recoverable from the claimant, allottees, of the unsold inventory in the project, list of the claims not received in case of the units are already sold, claims as per the books of account which not yet received, etc., litigations by or against the company, etc. These things are to be covered in the information memorandum very commonly. I have also come across a situation where the units allotted or the amount to be recovered from the home buyers, which was written in the SAP system or the books of accounts of the corporate debtor, was slightly or there was a variation from what was committed to the home buyers. So, say for example, the home buyers are given the unit at the cost of say 15,000 rupees per square feet, and the home buyer say a total consideration value is 2.5 crore. Home buyers have paid 2 crore. Then in books of the corporate debtor, it was reflecting only 1.5 crore payment is made. By actual payment was 2 crore, but 50 lakhs was paid in cash. But in the books, it was reflecting instead of 2.5 crore total consideration, that reflected 2 crore as a consideration, and they claimed 1.5 crore as received. So there was a variation on that. Sometimes even the amount has variations. As per the books of the corporate debtor, it shows different amount, and what is available with the home buyers or the receipt that is produced by the home buyers reflect different amount. So as per home buyers, as per the bank statement, receipt, etc., more payment is made to home buyers, but the book is showing or books of accounts of the corporate debtor reflects that there are outstanding amount. So those things need to be reconciled by the RP in discussions with the home buyer as well as with the promoters of corporate debtor. The support and cooperation of the promoters of the corporate debtor will be required there. That's why there is a discrepancy in this. And there, if required, necessary order or direction can be obtained from NCLT on those kind of transactions. Under Regulation 36, the RP may seek project-wise resolution plan for each real estate project. Now, in resolution plan, you need to be very cautious about when it comes to the real estate project. It is possible that pursuant to this amendment made in Regulation 4A and Regulation 36A, 4A deals with the opening of the separate bank account for project-wise bank account. Same way, Section 36, Regulation 36A also provides for project-wise resolution plan. So RP can seek resolution plan for each project. In one of the cases where I think it was HDIL case, where out of 8 project resolution, they initially for expression of interest resolution plan were invited, but ultimately the resolution plan was not accepted by the COC. But COC said, let's have the fresh resolution UI and invite the more intending buyers. In that situation, they also decided that instead of having collective all the project under one corporate data or having resolution plan for the entire corporate data, it is better and advisable to project-wise resolution plan. So they applied to NCLT and NCLT allowed project-wise resolution plan to be invited and accepted. I think out of 8 resolutions, out of 8 projects, 5 got resolved, 5 got resolution plan and 5 got resolved and 3 went into liquidation, something like that. So that was also a very interesting case when it comes to the resolution plan. Project-wise contribution or project-wise balance sheet, project-wise assets and liabilities are to be calculated. So this is very important when you are seeking resolution plan, and especially when you are going for project-wise resolution plan, then project-wise contribution, their balance sheet, their assets, liabilities have to be properly accounted for, and then the resolution plan can be achieved. Because if the home buyers of one project are satisfied and home buyers of the other projects are not satisfied, resolution plan may actually fail or may not get the requisite approval. अगर एक प्रोजेक्ट में पैसा ज्यादा है वो दूसरे प्रोजेक्ट में डाल रहे हैं और वहां से ट्रांसफर हुए हैं फंड्स, तो ये सारी चीजों में होम बायर्स विल नॉट बी हैप्पी टू अप्रूव दैट प्लान. So no one would like the surplus of the project is used for another project, etc. Especially when it comes to the escalation, such project contribution needs to be calculated separately, and the settlement may be made between the home buyer association of the projects if required. Many times, otherwise, even the home buyers internally fight. The different association of home buyers of different project, they internally fight for that because sometime surplus fund of a project is utilized for other project or transfer is made, all that kind of adjustment. So these things are to be separately accounted and calculated for. Now coming to section 16A, authorized representative. Now these are dealing with the rights, duties, and obligations of the authorized representative. Nothing much, but of course, as an AR, I can share a few practical things when it comes to it. IRP select IP, who is the choice of the highest number of financial creditors in the class in Form CA received under Regulation 12.1 to act as AR of COC respectively in class. That is the choice by home buyer in Form CA shall not be considered if the Form CA is received after time stipulated by in the public announcement. IRP shall apply to NCLT for appointment of AR selected under Regulation 12A within 2 days of verification of the claim received under Regulation 12. Till the application of the for the appointment of AR is pending before NCLT, the IP selected shall act as an interim representative of home buyers and shall be entitled to attend the meeting of the COC and shall have such rights and duties as that of a AR. ये पहले ग्रे एरिया था, initially when this provision came about the AR, many times we were always confused what to do because AR के तौर पे अपॉइंटमेंट एनसीएलटी से होती है, यहाँ पे होम बायर्स की मीटिंग पे मीटिंग हो रही है और AR अपॉइंटमेंट का ऑर्डर तो कितने महीनों के बाद आता है, तो तब तक एज एन AR हम लोग क्या करें, एनसीएलटी को अपॉइंट करने में टाइम लगता है, इट टेक्स मंथ सम टाइम. So by that time there will be 2 or 3 meetings of the very important meetings of the COC missed out. So वहां पे फिर AR के तौर पे हम लोग अनऑफिशियली एज सुपरवाइज तो करते थे, but we are not writing in our mail or anything that we are in capacity. We used to write AR as an applied. So now position is pretty clear about that they will act as an interim representation of buyers. So your position designation is very clearly defined in the new amendment that is made. Any delay in appointment of the home buyer shall not affect the validity of the decision taken by the COC. Home buyers representing not less than 10% voting share may seek replacement of the AR with an IP of their choice by making a request to IRP or RP who shall circulate such request to all the home buyers and announce voting window open for 24 hours. So यहाँ पे if you want to change the AR, initial AR all recommended by the IRP. So they give the 3 names. Out of the 3 names, if one of them will be appointed as AR, IRP will also apply to that for that AR. However, thereafter, if home buyer that they want another insolvency professional of their choice to be AR, then this process is required to be followed. That at least 10% of the voting share of the buyer shall apply for change or replacement of the AR. Subject to 4A, 2AB, the IRP or RP for choice of at least 3 home buyers, including such IPs proposed above, along with the existing IRP, shall provide the list of creditors in such each class to the representative AR appointed by NCLT. So IRP or RP shall provide the updated list of creditors to the home AR. So what IRP will do in that case, when they receive such representation, the IRP will give the choice of again 3 insolvency professionals. Out of the 3, one will be the one which is recommended by those representative 10% voting people. So one name which is recommended by those home buyers. The second name will be those AR which is already appointed or representing the home buyers. And the another third name, IRP or RP has to take. So 3 names will be given, but out of the 3 names, 2 names will be like this. The existing AR, the A is recommended by the home buyers, and the third one, out of then the 3, the voting shall take place. IRP or RP shall provide the updated list of creditors of home buyers to the AR as and when the list is updated. The AR shall have no role in or verification of the claim of creditors of the class C represent. Now, this is very important. The clarification is given in the regulation. The AR shall have no role in receipt or verification of the claim of the creditors of the class he represents. So, home buyer का claim examination वेरिएशन में AR का कोई रोल नहीं है. I have seen in many times home buyer आप AR बनते हो उसके बाद होम बायर आपके पीछे लगता है सर हमारा क्लेम है हमारा ये नहीं हुआ ये सारी चीजें दे आप उनकी सारी राम कथा आपको सुनाते हैं. Even in the home buyers meeting sometimes they say all these things, and so when we what I do is when I handle my assignment as an AR, I keep one meeting with the home buyer from my side only to educate them. It's very important. It is not written in the law. It is not given in the law. But that will make your job very. Once you explain to the home buyers that what is expected of them, once you explain to the home buyers that what is the role of an AR, once you explain to home buyers that how you represent to them as a COC and what the home buyer's voice is significant, once you explain to the home buyers that you have no role in examination or verification of the claim, or delay in examination or verification of the claim, or adjudication of any claims, then they will stop, calling you for things. Otherwise, they'll keep writing you things for their thing, and you will, under law, you are supposed to communicate it to the RP. So we'll keep you are just acting as a postman to forward all the details, whatever you receive from various home buyers to the RP. And those doesn't solve any problem because anyways the RP is going to do that and writing separately that mail to RP also. So it's a multiplication of efforts, time, efforts, everything is wasted. So it is necessary an AR, if you are acting in capacity as a AR, you are important person, you are dealing with the home buyers, you are common man, home buyers don't understand IBC sometimes, they don't understand the law sometimes, they require to be educated. So one of my meeting, once I am given an assignment, first meeting I do with the home buyers is to educate them and to show them this section 16A and my role as an AR and what are my roles as an AR, so that they also understand what they should expect from me and what they should expect directly from the RP. Of course, communication, whatever I receive from them, I forward it to RP. That is different thing altogether. But then something which is required to be done to RP, instead of having multiple mails, I ask them to simply mail it to me, marking CC to RP as well, because it is expected from the RP, and I simply say, "Dear RP, kind to the matter." So that's it. So बहुत सारे frivolous mail या जो cumbersome process सारे हों से आपको फोन कॉल्स आते रहते हैं या SMS आते हैं या व्हाट्सएप मैसेज आते हैं, ये सारी चीजें बंद हो जाएगी. I've seen many IRP, they stop communicating on WhatsApp or on email to any home buyers because of the multiple and plethora of mails that they are receiving from various buyers. That should not happen. That should not happen. Do understand they have invested their money. Only problem is that they don't understand the law so well. So you just need to guide them. Once you guide them, these things will stop. Unnecessary जो चीजें होती है वो खत्म हो जाएगी. खाली जो होम बायर की मीटिंग है आपके साथ वहां पे कुछ चीजें और वहां आपको क्लैरिफाई कर देना है, so that unnecessary mail, unnecessary WhatsApp, unnecessary reply and here and there and arguments will stop. So this is one important thing, that AR shall have no role in receipt or verification of the claim of the creditors in class 3 present. IRP or RP provide electronic means of communication between AR and the home buyers. The voting share of HB shall be in proportion to the financial debt, which includes an interest at the rate of 8% per annum, unless a different rate has been agreed between the parties. AR of the creditors in class shall be entitled to receive fees for every meeting of the COC attended by him in following manner. So now, as you are, fees are statutory. अभी amendment पिछले साल हुआ था तो उसमें increase भी किया है. So from 10 to 100 home buyers are there, then 30,000 for each meeting. If there are more than 100 home buyers, up to 1,000 home buyers, then 40,000. And if there are more than 1,000 home buyers, then 50,000 for each meeting of the COC. However, there is also further fees AR is entitled to receive for every meeting of class of creditors convened by in the following manner. So इसके अलावा अगर क्लास ऑफ क्रेडिटर से कोई मीटिंग होता है, यानी होम बायर से और कोई मीटिंग होती है, जो हमें करता हूँ, इफ आई एम द AR, आई डू टेक 2 मीटिंग्स एवरी COC मीटिंग के साथ में एक प्री COC मीटिंग करता हूँ, एक पोस्ट COC मीटिंग करता हूँ, एंड 2 मीटिंग एज पर लॉ. आगे हम आएंगे सी में, तो वहां पे देखा जाएगा कि यू आर एंटाइटल्ड फॉर 2 मीटिंग्स अंडर लॉ. 2 से अगर बढ़ती है तो फिर आपको यू नीड टू टेक अप्रूवल फ्रॉम द COC. सो 2 मीटिंग अलाउड है, तो मैं हर COC मीटिंग में मैं प्री और पोस्ट COC, उसमें क्या होता है, दैट बिकम्स वेरी सिंपल for them to understand, because what happens, once I receive the notice, I circulate to all the home buyers and ask them to have any observation and representation from their side within 12 hours window, whatever is given. And then I immediately have one meeting. साथ में एक मेरा मीटिंग होम बायर्स के साथ सेट कर देता हूँ, और वो मीटिंग में आई रेड आउट ऑल द नोटिस एंड व्हाट हैज हैपेंड, और क्या कॉम्प्लिकेशंस है, लॉ क्या बोलता है, नोटिस क्या है, व्हाट इज एक्सपेक्टेड फ्रॉम देम, एक्सप्लेन देम ऑल दैट. एंड देन मीटिंग होती है, तो उसमें वो लोग का जो व्यू है होम बायर्स के साथ के मीटिंग का, वो सारी चीज होती है, वो सारे व्यूज आई पुट अप इन द COC. सो होम बायर्स आल्सो फील जस्टिफाइड that their views or their concerns are raised in the COC meeting. So after the notice on relevant item of the agenda, the views of the home buyers I put up to the COC. Repetition, I ask them in writing also, but in the anyways, if they have made representation in the meeting with me as an AR, then I minute and then I circulate the minutes and then put up in the COC meeting. Then post COC meeting का एक मीटिंग होता है जहाँ पे पूरी मिनट सर्कुलेट होने के बाद, so that when voting is required to be done, they need support from AR कि how to vote upon. Many times they are confused, they don't know the law properly, they have their own concerns, they many technical things which are coming from the judgment they would not be well read of. So at times in that meeting, apart from reading the minutes of the meeting, I explain them what are the implications, what is going on, and then based on that they vote. So that is very important. So AR shall be entitled to receive fee for every meeting of the class of creditors convened by him in following manner, namely up to from 10 to 100 home buyers, 10,000 rupees, 100 to 1,000 home buyers, 12,000 rupees, more than home buyers, 15,000 rupees. So each meeting, the payment of fees to AR shall be part of the CIRP cost in respect of 2 meetings with the creditors he represent corresponding to the meeting of the COC. So law provides that up to 2 meetings, it is presumed a CIRP cost. They don't require any specific approval from the COC for that. It is enacted in the law, it is enacted in the regulation that it will be considered as a CIRP cost. But beyond that, so it comes in D, the fees for any additional meeting beyond the 2 meetings corresponding to the meeting COC shall be part of the CIRP cost subject to approval of the COC. So beyond 2 meetings if you are taking, then you require अप्रूवल ऑफ द सीओसी। बियॉन्ड 2 मीटिंग शायद ही कभी जरूरत पड़ती है, मेरे हिसाब से रिजोल्यूशन प्लान के टाइम पे जरूरत पड़ती है, या विड्रॉल प्रपोजल आता है तो वहां पे जरूरत पड़ती है। तो ये मेरे एक्सपीरियंस में ये 2-3 जगह पे हो जहाँ पे आपको डिस्कशन ज्यादा लगता है, वहां पे आप सीओसी में जो खाली मिनट्स में हुआ या जो आइटम डिस्कस हो रही है उस पर यू कैनॉट लिमिट, you need to discuss a lot of other things about the resolution applicant, about the commercial aspect, about the, you explain these things so that the home buyers can take decision. तो वहां पे कई बार 1 या 2 मीटिंग अलग से करनी पड़ती है। ऑफ कोर्स इट इज सब्जेक्ट टू सीओसी अप्रूवल। मैं तो मीटिंग वो कर क्या 2 मीटिंग सीओसी को अप्रूव करना है नहीं करे, मेरे लिए इंटरेस्ट ऑफ द होम बायर्स इज मोर इम्पोर्टेंट। So it is, even if the COC do not approve my cost, it doesn't matter to me. I have a meeting with the home buyers. That is important to educate them to take the informed decision. But most of the time I have seen COC is liberal enough to approve those kind of cost. एडिशनल मेरा 1 या 2 मीटिंग कभी कभार होता है पूरे ट्रांजेक्शन में, तो वो सीओसी अप्रूव कर ही लेती है। AR circulate the agenda to home buyers and may seek their preliminary views on any item in agenda to enable him to effectively participate in meeting of COC, provided that creditors shall have time window of at least 12 hours to submit their preliminary views, and the said window is open for at least 24 hours after the AR6 preliminary views. Such preliminary views shall not be considered as voting instruction by the creditors. So notice आती है, immediately we forward it to home buyers, and there we seek the representation and preliminary views of the home buyers. So whatever they want to presentations, etc., they should give in writing, or else preliminary views they should give in writing. Of course, it doesn't determine the voting pattern. AR shall assist the home buyers in understanding the discussion and consideration of the COC and facility informed decision. Review the content. Now, these are the duties of the AR. Very important. पहले जब आया था सेक्शन 16A, उससे भी अभी जो अमेंडमेंट हुआ पिछले साल में, उसमें काफी नई ड्यूटीज ऐड की है, और वो कुछ चीजें ऐसी है जो बहुत इंपॉर्टेंट जिम्मेदारी है, समझ के लेना है। सो रिव्यू द content of the minutes prepared by the RP and provide his comments on the RP. So this is also very important. कई बार minutes में चीजें have seen IRP और RP properly record नहीं करता या ignore हो जाता है होम बायर का, खास करके अगर इंटरेस्ट आता है तो कई बार वो properly minutize नहीं होता है। अगर वो properly minutize नहीं होता है या कहीं पर misunderstood भी होता है, miscommunication भी होता है, या कई बार कुछ क्लेम हम पुट अप करते हैं IRP को RP को कि भाई होम बायर्स कंप्लेन कर रहे हैं कि उनके क्लेम एडमिट हुए नहीं है या अंडर वेरिफिकेशन रखे हैं, या कुछ लोग प्रोविजनल रखते हैं, जो लॉ में तो नहीं है स्पेसिफिक प्रोविजन, लेकिन प्रोविजनल एक्सेप्टेंस ऐसा करके डालते हैं जबकि वो अंडर वेरिफिकेशन होना चाहिए, और कुछ लोग प्रोविजनली एडमिट करते हैं। तो ये सारी चीजों पे व्हेन वी पुट अप टू द IRP या COC में पुट अप करते हैं, कई बार चीजें रिकॉर्ड प्रॉपर हो ना हो, व्यू पे कम्युनिकेट हो ना हो, तो वो फिर सारी, इट्स वेरी इंपॉर्टेंट ड्यूटी ऑफ द AR टू write a mail to RP that we have perused the minutes, but these points probably are inadvertently not recorded. So we kindly record the same and consider this my mail as part of the minutes. So in next meeting जब ये review होता है तो वहां पे आपको ये you should consider इसको part of the minutes का बनाना है, या तो RP should recirculate the minutes with these points if those points are relevant and very important. Help the home buyers during the consultation made by the RP to prepare the strategy for marketing of the assets of the CD in terms of 36C1. Work in collaboration with the home buyer to enhance the marketability of the assets of the corporate in terms of regulation 36C3. Assist the home buyers in evaluating the resolution plan submitted by RA. Ensure that home buyers have access to information or documents required to form an opinion on issued discussed in the committee meetings. और यहाँ पे कई बार ये सवाल आता है, how to discuss about the resolution plan, information memorandum, because these are confidential documents, and all these documents are not to be discussed in open forum. Valuations, commercials, ये सारी चीजें कभी डिस्कस नहीं होती, जबकि it is one of the important duty of the AR to evaluate the resolution plan submitted, submitted by RAs. तो इवेल्युएशन करने जाएंगे तो चीजें बाहर आएगी, जबकि सारे होम बायर ने एनडीए दिया नहीं होगा। तो यहाँ पे यू वुड बी वेरी टेकफुल दैट व्हाट शुड बी डिस्कस एंड व्हाट शुड नॉट बी डिस्कस। कॉमर्शियल एंगल और ये सारी चीजें मैं उनको बोलता हूँ, आप एनडीए साइन करो, एनडीए मेरे को भेजो, एंड देयर आफ्टर ओनली इट कैन बी शेयर्ड बाय द आरपी। आई विल सबमिट इट टू आरपी एंड आरपी विल share the details with you. Resolution plan. If you have resolution plan, only then you discuss the relevant point with me separately. Otherwise, not. So these are few very important things which we take care. While we also perform the duty at the same time, we also ensure the confidentiality. Update regularly the home buyers on progress of the CIRP. Make suggestion for modification of the resolution plan as may be required by the creditors in class he represents. Record proceedings and prepare minutes of the meeting with the home buyers and act as a representative of the home buyers in representation before the NCLT, NCLAT and other regulatory authority. Now, this is something I wonder whether this can be one of the important duty or role of the IRP, to what extent it can be, how it can be interpreted. Because it is a representative so far as if it is only signing the petition is concerned, I don't mind. As an AR, it is signed by me. In capacity as a AR, I am or it filed against me, whatever. But if it is the representations before the NCLT, if I have to appear and argue the matter, then who will pay me for that? For pleadings, who is going to pay me for that? So this is where, if I go with the strict interpretation, then my role is very big. Act as a representative of the home buyer in representations before NCLT or NCLAT and other regulatory authorities. So the best of my interpretation case is it is intended merely to sign the petition. So you act as a representative for the home buyers in whatever representation that they make to NCLT or NCLAT. It does not involve the appearance or pleadings before the NCLT or NCLAT. That is what my interpretation is. That need clarity probably wherever the petitions are filed by the home buyers, but that is something probably needs a clarity. Provision regarding the minutes of the meeting in regulation shall apply mutatis mutandis for clause 9 I above. So minutes जैसे आप आरपी सर्कुलेट करते वैसे वो सारे उसके प्रोविजन, उसके जो मेंटेन करना है मिनट्स, वीडियो रिकॉर्डिंग मेंटेन करना है, ये सारी इसमें भी लगेगी. Home buyers may propose any additional responsibility upon AR about the representation of their interest in this. So these are few very important role and responsibilities of the AR. Regulation 16B, COC with only creditors, where the CD has only creditors in class and no other financial creditor eligible to join the COC. The COC shall consist of only ARs. यानी कई होता है कि खाली क्रेडिटर्स इन क्लास है, जरूरी नहीं होम बायर्स, हो सकता है डिबेंचर होल्डर्स हो, डिपॉजिट होल्डर्स हो, लेकिन वही लोग हैं, बैंकर्स नहीं है. तो एआर की फिर बनेगी सीओसी, जितने भी एआर है सब एआर की बनेगी. सेक्शन 16C, there are members of the creditors in class exceed 1000. Now appointment of the facilitator. Now this is also very important new thing that has come for the big real estate CRP. 1000 plus home buyers hai. So where the member of the creditors in class exceeds 1000, COC may direct the IRP or RP to appoint an IP other than IRP, RP or AR as facilitator for subclass within the creditors class, subject to the following condition. The appointment of the facilitator shall be considered only if only if after the first meeting of the COC, a subclass comprising of at least 100 creditors out of total number of creditors in class request for inclusion of the agenda for such appointment along with the name of the proposed facilitator. Solicitor. The total number of facilitator shall not exceed 5, and the fees of the facilitator of such subclass shall be 20% of the paid to AR, and such fees shall be part of the CIRP cost. The COC may replace the facilitator on of majority of the members of subclass. Roles and responsibility of the facilitator. The facilitating communication between the AR and the credit class subclass, attending the meeting of the COC as observers to facilitate communication between the creditors of subclass, providing information and clarification to the creditors in subclass about the CIRP as per the advice of AR. So now here advice of AR is important, and any other task assigned by COC to improve the representation and communication. Rule 18.4, where CD has any real estate project, the COC may direct the RP to invite competent authority. That is under CII. Authority as defined under section 2P of related to such project to attend the meeting of the COC, as the COC may decide without voting rights for providing the input on matters associated with the development of the project. So ये भी एक अच्छा मूव है जहाँ पे competent authority को आप invite कर रहे हो. Of course, they will not have right and all. But then you invite that regulatory authority, because many times I have seen in real estate project there are discrepancies on what is the knowledge of the competent authority or the RERA authorities and the knowledge of home buyers or the knowledge of RP also sometimes. So what happens? Many times they declare, the corporate debtor or the ex-promoter declared that I've done the construction activity 60%, but actually ground reality में देखने जाओगे तो 20% भी नहीं किया होता है. But such declaration is made to RERA authorities. Now their situation, when it comes to the COC meeting, these things can get resolved. Regulation 25, we shall circulate the minutes of the meeting by electronic means to all the members of the COC and the AR, if any, within 48 hours of the conclusion of the meeting. Provided that on a request for extension made by the creditors, the voting window shall be extended in increment of 25 hours. AR shall circulate the minutes of the meeting received by him to home buyers and announce the voting window at least 24 hours before the window opens instructions, and keep the voting window open for at least 12 hours. So this is how the voting will happen for home buyers and AR. Now, this is also very important about audit of the corporate debt, includes the forensic audit as well, and report on the status of the development right and permission of the real estate project. Now, these are all has been into the amendments from recently. Regulation 30B says any COC member may propose an audit of the corporate debtor with objective scope, estimate of cost, time frame, and names of the proposed auditors. Proposal made above shall be considered as per Rule 18.3, and audit shall be conducted if such proposal is approved by COC. Audit shall be conducted by an IP having qualification required for such audit. Auditor shall prepare a report detailing his finding, and the same shall be presented before the COC along with the comment of the IRP or RP. The expense of such audit shall be treated as CIRP cost. Now, one of the real estate company where I was representing, I share the experience. What happened is the initial COC was then made of the bankers and financial creditors, whereas the appointment of AR was not made. The appointment was made later on, and it was applied to the NCLT for approval, etc. So the first meeting of the COC, AR was not present. Whereas if you see the overall letter on the constitution of the COC, there were around 65 to 70% of the home buyers were there, while the other creditor were hardly 30% or so. So therefore, but the appointment of auditor was made in the first meeting of the COC. Now that was surprising that in the first meeting, the transaction auditor was appointed, which was recommended by of the financial creditor, and it was agreed by the financial creditors. Thereafter, for the entire CRP period, whole 180 days, the transaction audit report, which was required to be provided, was not provided because the transaction auditor says we are not getting the information from the promoter. There was a non-cooperation in the management and all. There were also signs home buyer felt that probably there are confusion between the transaction auditor and the respective ex-management of the corporate debtor, or between the financial creditor and the financial creditor and the builder, because they were surprised to see project going into CIRP. They were surprised to see कि इतने छोटे अमाउंट के लिए फाइनेंशियल क्रेडिटर्स इंसॉल्वेंसी फाइल किए. So ये क्यों हुआ है? Is it merely for the purpose of haircut? And there were a lot of cash payment transaction which was made in the CIRP. So cash payment, then there were no entry in the bond, and the home buyers were not having adequate proof to show, reveal that cash payment was made. तो वो सारा अगर क्लेम एडमिट होता है तो सीधा हेयरकट में आ जाता है, because that claim cannot be admitted. They will not be having any proof for the payments which they have made. And those transactions, if claim, it goes into fraudulent transaction to forensic में. तो forensic auditor भी पहले से अगर colluded है तो पूरे transaction में एक बहुत बड़ा loss home buyer को हो रहा था. So in that situation, you may need to then go through the NCLT route saying that why the entire transaction audit was not provided throughout the CIRP, and by what audit they have done, the things which are surfaced or revealed has not been come before the COC. It has not been disclosed to the COC. Transaction audit logically has not happened. So seeking direction from the court that time to have another transaction to do proper transaction audit. Also, now because of this provision, this can be recommended now by the members itself. Because of the made, the COC members, that is the AR of the home buyers, can put up the suggestion for having another transaction audit or additional auditor look into this transaction, because the earlier auditor is not providing the report. So this is one of the important things, which will report on the status of development right and permission of the real estate project. Where CD has any real estate project, RP shall prepare the report detailing of the development right and permission required for development of such project. Submit the report to the COC for its comment and submit NCLT. The report referred to in clause A along with the comments of COC referred to in clause B on or before the 68th day of the ICD, insolvency comments. So this is also important made. Apart from that, CIRP costs, you all are aware that fees payable to out of pocket expenses of the AR. कई बार ये पता नहीं होता है AR को भी out of pocket expense में क्या ले. So that is also, it's a part of the CIRP cost. Fees payable to the facilitator, that is also covered in the CIRP cost under regulation 31. So these things are covered in regulations. Apart from that, regulatory fees, which is required to be paid, we all are aware that regulatory fees are calculated at 0.25% and realizable value of the creditors under resolution plan approved under section 31. The plans which are submitted after 39/2022 shall be payable to IBBI where realizable value is more than the liquidation value. Regulatory fee calculated at 1% of the cost being booked in the CIRP cost for hiring the professional of the IRP for assistance in the CIRP shall be payable to IBBI in manner specified in Regulation 7 to CB IBBI IP Regulations 2016. Now here an exception is there. Explanation: it is hereby clarified that regulatory fees under this sub-regulation shall not be payable in case where the approved resolution plan in respect of the resolution plan is a real estate project, is from an association or a group of allottees in such real estate project. So if the resolution plan is made by the allottees or group of home buyers, then that percentage of regulatory fee is not required to be paid to IBBI. Lastly, Regulation 36A, invitation and expression of interest. It shall publish in brief particular about the RP shall publish brief particular about the invitation of expression of interest in Form G of Schedule 1 at the earliest, not later than 68 day of the ICD from interested and eligible prospective resolution applicant to submit the resolution plan. Clarification is made in this. The RP after approval of the COC may invite resolution plan each real estate project or group of the projects of the CD. So, as I said, this is about the project wise RP or reverse insolvency में भी ये काम आता है. So, that can be done with the approval of the COC to have project wise resolution plan. The detailed invitation shall specify the criteria for prospective RAs as approved by OC under section 25(2)H, state the ineligibility norms under section 29A to the extent applicable from prospective RAs, provide such basic information about the CD as may be required by prospective RAs for expression of interest, not require payment of any fee, non-refundable deposit, submission of expression of interest, provide details of the CD's registration status as MSME under MSMED Act. Now, once the company goes into CIRP, now there was a recent change in the MSMED limit. So many companies which were not there earlier in MSME now is because their threshold is within 50 crore, are now falling within the threshold of 50 crore and now under MSME. But if the company is already under CIRP, the promoter will not be eligible to apply for it because they fall under MSME. They'll not be able to apply because the control is now with RP. Anytime the question arises, can the promoter or ex-management of the CD require RP to submit or application for MSME in the under MSME Act, register itself for the MSME? I would require for the simple reason that under MSME, you know that even the ex-management can provide the resolution plan. They can submit their bid. So if the company comes under MSME, they will also will have the opportunity to submit the resolution plan and all that. But can they force RP or COC to submit or apply for MSME? Answer is no. There is an NCLT judgment recently in one of my matter where the ex-management had filed an application in IA seeking a prayer direction from the NCLT that NCLT should direct the RP to apply for MSME, and it was clear view of the NCLT that this is a commercial decision of the COC. If they don't want to apply, they may not apply. NCLT will not pass any decision on that. It's a discretion of the COC and the RP to apply for MSME. Provided that where city has any asset project, the COC for an association or a group of LOT in such real estate project representing not less than 10% or 100 credit of the total number of creditors in a class, whichever is lower, may relax the following. The eligibility criteria for submission expression of interest provided in clause A above, and B, condition relating to the refund of the deposit. So this is where you can give the flexibility. It is a resolution plan is submitted by the Home Buyers Association. Request for resolution plan RFRP. The request for resolution plan shall require RA in case the resolution plan is approved under section 30 subsection 4 to provide performance security within such time specified therein, and such performance security shall stand forfeited if the RA of such plan after it's by the NCLT fails to implement the or contribute to the failure of implementation of that plan in accordance with the terms of the plan and implementation schedule. Provided that the CD has where the CD has any real estate project, the CO relax the requirement to provide the performance security for an association or a group of LOTs in such real estate project representing not less than 10 or percent or 100 creditors out of the total number of creditor in class, whichever is lower. तो जहाँ पे होम बायर एसोसिएशन ये करता है तो वहाँ पे फ्लेक्सिबिलिटी है to seek the performance guarantee from allottees or home buyer association. This is very clear. Many times query also arises about delay filing of the claim beyond 90 days and all. So there I think regulation 13(1), 1A, B and AC is very clear to everyone. So I'm not reading it again. If there is a delayed filing, what process IRP or RP has to follow in general, not necessarily for real estate project, but it also applies to real estate projects. So that process is to be followed. Similarly, now when it comes to the definition of LOT, when it comes to the definition of LOT under RERA, just for the understanding purpose, I'm taking this because sometimes there is a confusion about who are under RERA. So just for the understanding purpose, what definition is given under RERA? It says that in relation to real estate project means a person who a plot, apartment or building as the case may be has been allotted, sold, whether a freehold or a leasehold, otherwise transferred by the promoter and includes a person subsequent acquires the said allotment through sale, transfer or otherwise, but does not include a person to whom the such plot or apartment or the case may be is given or rent. So rental transactions are excluded. जो live and license वगैरह है वो सब नहीं आएगा, tenancy नहीं आएगा. So what word is plot apartment. Now here the definition of apartment is there. That is very important because those whom the apartment is also allotted, they are also covered definition of allotting. An apartment in broad sense covers most of the things. And it goes by the principle what can be considered as flat or apartment. So apartment, whether called block, chamber, dwelling unit, flat, office, showroom, shop, godown, premises, suite, tenant, unit or by any other name means a separate and self-contained part of any movable property. ये बड़ा important है कि how you define that. Either land is not the flat or apartment. It should be separate and self-contained part of the property. यानी कि समझो एक रूम है उसकी 4 वॉल है, so it can be separated from that wall. From other room it can be separated. So that is a separate and in itself. That room itself is a self-contained room. That is very important. The criteria to determine a property as a apartment or a flat, okay, including one or more rooms or enclosed spaces located on one or more floors or any part thereof in building or a plot or land used or intended to be used for residential or commercial use. Again, the use is defined. If you compare this with the definition under MOFA earlier, now this is the RERA definition. In MOFA earlier, there was also commercial activity use was covered. Here they are not specifically talking of industrial use, but this is in my view of just a exemplary things. But commercial or residential use are covered. But in those which are in industrial gala also, whether they are covered or not, there are few RERA judgments on that. That they don't RERA authority or RERA court judgment is there that probably they don't cover under the RERA Act. They are covered under maybe MIDC Act or those kind of laws. But logically, the principle, if we go by separate and self-contained, it may be probably covered by wider meaning of it, such as the shop, showroom, godown, or for carrying on any business, occupation, profession, or trade, or for any other type of use ancillary purpose specified. So when I am talking of any other type ancillary to the purpose specified, so purpose specified is trade. For trade, if I am doing the manufacturing in a, so that cannot be covered in apartment. It's a subjective thing. And certain real estate project again means a development of the or building consisting of the apartment or converting an existing building or part or thereof into apartment or development of land into apartment, as the case may be for the purpose of selling. All all or some of the said apartment or plot building, as the case includes the common area, the development works, all improvements and structures thereon, and all entitlement rights or appurtenance belong thereon. So ये रेरा की definition from where you are getting when you say read section 58F, those LOTs which are covered under LOTs of the real estate project under RERA, they are deemed to have commercial effect of borrowing, and therefore that deemed to be a financial creditor. So वहां पे ये definition काम आता है. As I said, that definition is merely a deeming provision, clarificatory provision that is not limiting the overall section 58F. The meaning widely interpreted 58F about talking about any transaction and any amount raised under any transaction having commercial effect of borrowing. तो वो उसको लिमिट नहीं करता है. This example given to clarify the position. I hope it's very clear. So with this, so far as my session is concerned, I think I've covered the things which we face in the real estate project. Now we'll go with the question answer session. If you have any query, doubts, or question answers, it can be taken. Is there any questions?
Hello. Hello.
Yes.
Yes. Harshul, why this is Yogesh Sharma? This is Yogesh
Yes, Yogesh.
Sharma, IP. Thank you for this thank you for very this interesting session. Coming from experience, lot of experience which you have. My this is very peculiar situation. Home buyers inclusion in
You are not audible, sir.
as a financial writers pari passu. This kind of
Sorry,
provision.
you
This
are
is
not
very
audible.
unique to India, probably. Sorry.
You are not audible. Can you just repeat?
Yeah. So I'm saying this is very unique provision which IBC Indian IBC have included home buyers as financial creditors pari passu in my question is as a home buyer they are the customer as well and they are the financial creditors as well. So their interest may
Yes.
also clash in COC with the financial creditors, right? So how as
Right.
a IP, how do you manage or how do you one manage those kind of conflicts?
See, for conflicts of so far as their clarification and
Because
verification is concerned,
because the financial creditors would be not interested in something else. They are interested in recovering their money. Where the home buyer's interest
correct.
might not be in recovering money, or they might be interested in something else. And they want their deliveries or possessions of their homes or whatever. So this is
Correct.
very
They will
peculiar
get their
kind of
flats.
scenario. Sorry.
Recovery of house.
They will
Yeah,
get their
recovery of house.
residential or commercial flats. Yeah, flats
Yeah, so
or
they want
commercial
flats
premises.
and the financial creditor wants the money. So which is
Correct.
sometimes I don't know very difficult situation for IP to manage the expectations from all the sides. So what do you think about it? What is your take?
So expected definitely say when you are dealing with such situation, you have to take AR in comments. You have to tell the AR to have proper deliberations with the home buyers, explain them the situations. Anyways, the things will be happening. COC. We also ensure see when we convince the home buyer, we say that you should be concerned with the home, your flats or your premises. Even those who are coming in the real estate resolution, all the resolution applicants, they will definitely give the property. Their flat will get constructed and they'll be getting the possession of the flat. So far as they are getting the possession of the flat, they don't have too much of issues. Home buyers, unless they have escalation or there are money which is misappropriated from the projects. In that
Yeah.
situation, the home buyers have issues about the escalation and all those kind of things.
Hmm.
So in
But
those
with your
situations,
yeah,
yes.
sorry.
So in those situations, we have the deliberations. We do explain the situation. We deal with them that if there is an escalation, say tomorrow there are recoveries made from fraudulent transactions, preferential transactions, etc. We can give them a flexibility to the home buyer that will be adjusted towards their escalation. So that will be adjusted towards the money bringing back to the project. So we can give that kind of comfort to them that tomorrow if we recover this money, why this deficit is there? Why there is a default and deficit? because the money probably is siphoned off or taken away for some fraudulent transaction or some other means, and which are now difficult to trace. And that's why the
Hmm.
project becomes unviable many times. So in that situation,
You know,
if the applications are filed, maybe in resolution plan or resolution applicant may give this kind of slight comfort zone to the home buyers that they will flat, of course, maybe initially with escalation, but if the money is recovered and project becomes viable, then probably that time this escalation amount will be adjusted to that. That may give them slightly more comfort zone.
hmm, I see. You know, a very, very complicated situation when hundreds of home buyers with representing through AR, and anybody can disagree and challenge the whole situation.
Yeah,
So
so but
this is
we
really.
cannot. When I make as a RP also, law doesn't require if I am IRP or RP in presence of AR in one of the AR's meeting, usually initial meeting,
Hmm,
AR take, I remain present and I would like request AR to allow me to speak for 5 minutes, if possible, to
hmm,
discuss with my home buyer.
hmm,
Wherein I explain to them, I do understand this is an insolvent company going into
hmm.
insolvency. तो सबको खुश करना तो possible नहीं हो. From the very
Why,
beginning, I
that is
tell
the
them.
that is the biggest challenge, in this kind of
So when I
proceedings.
tell them from the very beginning कि सबको कुछ ना कुछ तो haircut आएगा, contribution आएगा. Everyone should know that. इंसॉल्वेंसी ये इंसॉल्वेंट प्रोजेक्ट है, ये ग्रीनफील्ड प्रोजेक्ट नहीं है जहाँ पे सब कुछ एकदम फाइन है. तो भाई क्या
Hmm,
आएगा आगे, कैसे चैलेंज आएगी, चाहे लिक्विडेशन में
hmm,
जाने से ज्यादा अच्छा है कि रिजोल्व हो जाए. हो सकता है
hmm,
आपको
hmm,
थोड़ा
hmm,
कष्ट, हो सकता है आपको ज्यादा इन हो, या थोड़ा सा आपको दुख हो के अपने पैसों के लिए, या एस्केलेशन आए, या कुछ प्रॉब्लम आए, या टर्म्स में इशू आ रहे हैं,
hmm,
ये सब में थोड़ा
hmm,
कॉम्प्रोमाइज आपको करेगा.
hmm,
आई एक्सपेक्ट माई होम बायर्स, वो मैं पहले ही उनको ट्राई करता हूँ कन्विंस
hmm,
करने की कि मैं आपके लिए लड़ रहा हूँ,
hmm,
ये रिकवरी के लिए सबके
hmm,
लिए लड़ रहा हूँ, सारे होम बायर्स के लिए,
hmm,
सारे स्टेक होल्डर्स के
hmm,
लिए. तो मैं जब
hmm,
ये कर रहा हूँ तो मुझे आपका सपोर्ट लगेगा. आई बेक फ्रॉम देम दैट सपोर्ट
hmm,
फ्रॉम द वेरी
hmm,
फर्स्ट
hmm,
बिगनिंग
hmm,
इन द इटसेल्फ. और मैं उनको सामने से बोलता हूँ कि थोड़ा तो पेन आएगा, सबको आएगा, होम बायर्स को भी
बट
आएगा और
इसमें
फाइनेंशियल क्रेडिटर को भी आएगा, लेकिन लिक्विडेशन में जाने से अच्छा है ये. कम से कम अपने फ्लैट तो
with with
मिलेंगे.
with with your experience in these matters, सक्सेसफुल रेजोल्यूशन होता है? मतलब होम बायर्स को होम मिलते हैं एंड फाइनेंशियल क्रेडिटर को
बिल्कुल
पैसा
होता है,
मिलता है? होता है?
बिल्कुल, ऑफ कोर्स.
Thanks.
थोड़ा हेयरकट होता है, ज्यादा करके मोस्ट वल्नरेबल इसमें जो अनसिक्योर्ड क्रेडिटर होते हैं, क्रेडिटर
हाँ,
होते हैं, वो सब
ऑपरेशन
दे लूज.
ऑपरेशन, हाँ. हम्म,
सो दे लूज लॉट ऑफ मनी. और
हम्म,
अनसिक्योर्ड फ्रेंडली लोन वाले बहुत सारे लोग होते हैं जो उनके पास कोई प्रूफ नहीं होता, वाले टेस्ट ट्रांजेक्शन में हेयरकट
हम्म.
आता है,
Yes,
वो
and
सब में
most of this,
दिक्कत रहती है.
yeah, most of the real estate guys works on the friendly loans, through the back
करेक्ट.
channel funding. तो उसका
तो
क्या
वहां पे
होएगा?
वो
उसका
सारे
तो किसी.
प्रॉब्लम्स आते हैं, और वो भी क्या होता है, एक्चुअली फ्रेंडली लोन होता है ना, तो
हाँ,
बिल्डर उसको अलग तरीके से कंफर्ट जोन दिए रहा होता है. वो प्रमोटर जो है वो अलग से बोलता है मैं दूसरे यूनिट दूसरे प्रोजेक्ट में दूंगा, दूसरे प्रोजेक्ट में
उसको
पैसा दे
फ्लैट
दूंगा.
फ्लैट फ्लैट दे दूंगा, कुछ यूनिट दे
हाँ,
दूंगा,
दे
वो कर
दे डू
दूंगा.
अदर काइंड ऑफ ऑल बैकएंड में बहुत सारी चीजें चलती है. जो
हम्म,
अनसिक्योर्ड क्रेडिटर यहाँ पे तो लूज करता है, लेकिन बैकएंड में कुछ और प्रोजेक्ट कहीं ना कुछ तो एडजस्टमेंट वो लोग करते हैं.
चलता है ना, बिकॉज रियल
बट
एस्टेट इंडस्ट्री वर्क्स ऑन दोज पैरामीटर्स, राइट? देयर आर
करेक्ट,
50%
दैट
इन
इज हाउ इट वर्क्स.
50% books and 50% may not be in books somewhere.
So correct. So that is how those projects are done. So far as you are doing your duties, it's fine. You are not giving any commitment to those things. It is between the
Hmm.
builders and ex promoters and whatever backend में वो लोग जो करते हैं, कम से कम it is never in the records. As an
Hmm.
IRP or
Hmm.
RP, I don't indulge in any of those activities. Backend में उनको जो
Hmm.
करना है करें. मेरा
Hmm.
अगर हेयर कट आ रहा है, हेयर कट आ रहा है. If to file,
Hmm.
they can file, get the
Hmm.
resolution in the NCLT.
Hmm. Yeah. Okay.
यहाँ पे
Thank
बहुत
you. Thank you,
इम्पोर्टेंट है,
Harshul
When
bhai.
we start
एक
this
और चीज है
CIRP,
यहाँ पे जो इम्पोर्टेंट है. इन वन ऑफ द
हाँ,
CIRP what I was handling, now
हाँ.
the transaction is over also, so I don't know whether I can name that Aristo developers. One of the
Hmm.
transaction that I was handling,
Hmm.
ये ऐसे ट्रांजेक्शन बहुत संभालना होता है जहाँ पे गारंटर्स आते हैं, कॉर्पोरेट गारंटर्स.
Uh,
Now this again
hmm.
as
Hmm.
is even to the IBPI, one of the thing that ये बड़ा अजीब ट्रांजेक्शन हो जाता है. लीगली कितना वायबल बनता है मुझे नहीं पता, ऑफकोर्स लॉ में है और वो you have to go by IBC. Now
Hmm.
in one of the transaction that I was handling, There I was a consultant in that transaction. So what was happening that one banker was there, rest home buyers were there. They collectively, and then the big corporate one claimant of the creditor, where my corporate debtor had given the guarantee. So say there is a company A, okay, and there is a company B, which is a group company. Now company B has taken a big loan, which is a group company, from a creditor, maybe a lender, whomsoever. And company A has given a guarantee for that. Okay, and that amount is so big that now company A goes into CIRP, corporate debtor. Now, because it goes into CIRP, the creditor will make claim for the on that company as well, because they are the guarantor, corporate guarantor. And that claim is so big, which constitute around 67%. Now, again, that voting percentage becomes very important. This lender constitutes 67% of the COC. In the first meeting of the COC, he replaced RP. He replaced IRP he brought his RP. In the first meeting of the COC. Okay, his claim was admitted. Now, just imagine the situation. The company who is controlling the COC with 67% has not paid a single rupee to my company. And he is claiming 67%. He controls the RP because he has appointed RP in a way. So I can't say officially it's a collusion, but it is appointed by him. He pays RP and he appointed his RP. He holds 67% in the COC. So all the resolution can be passed as per his requirement. Now, whether this corporate guarantee to what extent it is legitimate and genuine also we don't know. Because that was, this corporate guarantee was made after filing of the CIRP in the NCLT. But before the, of course, CIRP order was passed. So it was not even filed with the ROC or MCA. Ministry of Corporate Affairs में उसके 4 register भी नहीं थे. And they said because the company went into NCLT तो हम लोग file नहीं कर पाए. Or before that order pass हो गया. So we could not file it in the NCA before the MCA. तो उसकी genuineness, manufactured document था very subjective. And look at the situation, the company who has not paid a single rupee to my company is controlling the entire COC. And in that, when I said you follow the principle of subrogation, अगर ग्रुप कंपनी ने लोन लिया है तो सिक्योरिटी उससे क्रेडिटर को दी है, वो क्रेडिटर और सिक्योरिटी लाओ. दे आर आई शुड एंटर इन द शूज ऑफ दैट क्रेडिटर. तो वो भी बहुत सारे लोग समझ लीगल इम्प्लीकेशन सीओसी में लीगल अगेन लीगल पीपल डोंट अंडरस्टैंड because there it's a commercial buildup. Neither bank insisted for that nor home buyers insisted for that. Where I was a consultant for home buyers in that matter. But then the home buyers को बाद में मेरे को समझाना पड़ा, लेकिन शेख इतना नहीं था कि we can command over that. So in that situation, what a situation that emerged was someone who didn't pay a single rupee to my company, controlling the entire CIRP, going to take around 67% of the resolution. And who is the sufferer is the unsecured loan, and the bankers were paid in that, but unsecured loan was sufferer. So they lost all money. Otherwise, the company was in a way, they could have paid probably everyone. There was enough money. It was a safe.
Yeah, I think these are the complications in the home buyer scenario, because home buyer, adds fifth dimension to the entire thing. Otherwise you have financial creditors, you have operational creditors, you have employees and other governments, those kind of stakeholders. And these guys comes in, home buyers comes in, that adds more complications to the whole thing. And the problem is that they are individuals. So some of them individuals doesn't have that kind of knowledge, so. And sometimes, the formation of AR, etc., also takes time to convince them and make that happen. A huge task for IP in the process,
Correct.
Yeah.
No, my consultation when I was given to home buyers, ultimately we challenged it, and then, but later on it got settled. Home buyers said, "छोड़ो ना, आपको अपने घर मिल रहे ना." So let's not fight for, because our rights are protected. So ultimately we gave up that issue. Instead of fighting, we went to NCLT, but we dropped it later on because it got settled. Home buyers were given the flats, and based on the same terms, same commercials, same location, all those things, whatever they wanted. So in resolution plan, we protected ourselves properly. But then this issue still remained, and in my view, this is very significant. Otherwise, people can manipulate it.
Sir, I think in this real estate projects, I think resolution professional's job is somewhat, I think, more complicated than the rest of the insolvency cases, isn't it? Now they have to do a lot of analysis about the project and the status of the project, how many projects are there, whether a builder is there or a builder developer is, owner is there. All these things are to be taken into account, and then after doing that, he has to ascertain whether which financial creditor is the secured, unsecured, or which financial creditor is given the flats, not given the flats, and NOCs are up. Lot of things are involved in this real estate project.
Correct. So already that's what I'm saying. Already there are so many dimensions to it. This home buyers adds more dimensions to it.
Yeah. So in case the financial creditors, when we classify the, flat owner, flat buyers, home buyers, into financial and non-financial or operational, they may be operational creditors or as well as financial creditors in the home buyers class, sir.
Sorry, could not get.
We are taking the home buyers as a whole lot, and in this home buyers, will there be a case, an occasion where the home buyers will come into operation creditor part and financial creditor part?
Home buyers, if they are home buyers, they are operational creditors. There are other type of creditors like resettlers. Resettler will come within the meaning of other secured creditors, other creditors.
Operational creditors. No. Financial
No,
creditors.
other creditors.
Other creditors.
Other creditors. Secured
in a normal course of
when a home buyer will become an sir, when a home buyer will come as an operational creditor, you said something.
Why would they come operational creditor? No. They would not be operational creditor. Achha, operational creditor. Okay, I understood.
You told
now there are few flats which are allotted to the service provider. Say in a project, carpenter is working, electrician is working, and their bill is so big. Their billing rate, which sometimes runs into lakhs and crores. So what they, instead of making payment to them, the corporate data, what they do is they don't want to give them liquidity. So they say, instead of against your invoices of work which you have performed in the project, I am giving you one flat. So logically, when they are giving the invoices for the services like carpentry,
the flat is given as a consideration for the services given.
Yeah, services given. So then
for
they are
the services given, he is
logically
giving an allotment of a flat.
Correct. So logically, they are operational
then
creditor.
he becomes an operational creditor.
Correct. So he is an operational creditor. Then he is upgraded to financial creditor by giving flat. Okay, by giving flat, he becomes a home buyer.
Sir, can you?
Harshul bhai, there could be one more scenario wherein a service, a supplier of material to the to the real estate guy.
Correct.
In his individual capacity, books some flats. In that case, he's a financial creditor as well, and he's an operational creditor as well.
Yeah, if he has supplied the goods for that, if he is having a separate invoice, then he has their operational creditor in that case, and when they book the flat separately, then they are financial creditor. But if against the material, the flat is allotted to them. But what happens is, builders run away from the liquidity issue. They suffer from liquidity. So what happens, अगर payment करना है, बड़ा payment करना है, material supply हुआ है, payment बड़ा करना है, लेकिन अभी पैसा नहीं है, liquidity हाथ में नहीं, तो what they do is for convenience they say, okay, एक flat तू ले ले, so particular flat is booked in there. Now that if you see, consideration is not moved to the corporate debtor in terms of check or cash. पैसा दिया नहीं है, material दिया है साहब, it's a barter kind of thing. But now material अगर उसने supply किया है, तो what invoices he has raised, he is a operational creditor. अगर उसके सामने उसको flat दिया है, तो फिर he is a home buyer In that case, you are converting the operational creditor into a home buyer or a financial creditor, secured financial creditor in a way. So that is something, becomes a preferential transaction to that extent. So वो सारी चीज they have to obtain the proper order from Honorable NCLT to adjudicate upon it. You have to admit their claim first, because claim तो है तो genuine है, उसका जो भी reason से उसको flat allot हुए हैं, वो claim तो genuine है, claim admit करना है और वो preferential transaction में डालना है. So that is required. इनमें फॉर्म होम बायर तो है, उसका एग्रीमेंट फॉर सेल तो होगा, तो चीजें, लेकिन कंसिडरेशन नहीं है, कंसिडरेशन कैश में नहीं है. तो वो सारी
one
चीजें हैं,
case,
इसके कारण आपको वो सामने कंसिडरेशन बुक ऑफ अकाउंट्स में चेक में या कैश में नहीं मिलेगा. सो इन दैट सिचुएशन यू रिक्वायर things to be adjudicated through NCLT, that this can be looked into as a preferential transaction, that instead of making payment to them, the flat is initiated in where a preference is given to them to an operational creditor.
Sir, in one case, you said that reverse CRP is a decision taken by the NCLAT as a judicial this innovation. What is that case,
Yes.
sir? Which case is that?
Umang Realtek.
Pardon,
Umang
sir?
Realtek case. Umang
Umang
Realtek.
Umang Realty.
The first case that I referred, Umang Realtek wala.
This
In
is
that,
NCLAT
that is the first
Delhi.
case. It was in NCLAT Delhi, yes. It was held by NCLAT Delhi.
But this IBBI can ignore this case, sir. Whether they can incorporate in the IBC also, no? If it is a perfect one, that concept is a
Concept
good
is
one.
perfect, but on case to case things would differ, na, sir. For that, it is required that a project should be able to complete. So on case to case basis, this will be decided whether it is possible. There are cases where NCLT के सामने गए हैं for exclusion of the project, और वो प्रोजेक्ट अभी 20-30% कंप्लीट हुआ है, तो एनसीएलटी ने मना किया है कि ऐसे एक्सक्लूड नहीं कर सकते. मैं दे आर वरीड कि लिक्विडेशन में जाएगा तो कुछ भी नहीं मिलेगा. सो वो वैसे केसेस में जहाँ पे कंप्लीट नहीं है, प्रोजेक्ट इनकम्प्लीट है, आगे होने का ना फंडिंग होने के थे, आगे कैसे कंप्लीट करोगे, तो वैसे केसेस में वो रियर सीआरपी नहीं हो सकता जस्ट बिकॉज होम बायर से कि हमें इसमें से एक्सक्लूड करना है और हमें अलग कर दो, तो वैसा नहीं होता है. देयर शुड बी, एज आई सेड, क्राइटेरिया शुड बी मेट that it should be about to complete in next maybe 2-3 months. Completion stage में है. Even promoters or the corporate debtor can complete the project with the requisite funds. जो भी funds available है उसमें से वो complete हो सकता है, या तो वो funds का arrangement हो चुका है by whatever way, through some banker, lender, whosoever, और उसको आपने interim finance के तौर पे लिया हुआ है, और वो complete होते ही सारे possession जो है वो होम बायर को आप देंगे. ये सारी क्राइटेरिया अगर मीट होती है तो ही रिवर्स सीआरपी हो सकता है. अदरवाइज एनसीएलटी विल नॉट. बाकी तो सब लोग मांगेंगे कि हमको हमारा प्रोजेक्ट अलग कर दो. दैट कैन नॉट वर्क. होप इट्स क्लियर.
Yes. Yes. And very nice discussion, very nice presentation. Yeah.
Thanks. Thank you so much, sir.
Good one, sir. Good one.
Yeah, good discussion.
That's why I've written the presentation, that if someone wants to have the notes of it also, I can share the presentation. That's why I keep the things in writing.
What we heard is that you will be sharing this PowerPoint presentation to the institute, and thereafter, the last 5 days, the classes are happening. All 5 days, this PPTs will be shared to us. Can you share it to them?
I'll share it. Now, I've made a note, instead of making just a PPT presentation and diagrams, I thought if I make a diagram, a lot of things I'll be speaking, but people will not get the correct picture of it. So instead of that, I make just like a notes so that you can anytime refer it. The presentation I have made an effort.
I will send a mail to you, sir, and I will.
Yes.
That you
definitely.
can send it to me. Thank you.
Sure, sir.
Thank you. Thank you, Harshul. Thank you.
Shall we end? Thank you. Yeah.
Thank you.